of the Senate Judiciary Committee will come to order. Over the past year, Americans have learned a painful lesson on the dangers of judicial activism. Lives have been disrupted, life-saving health care has been declared illegal, and women have been denied their fundamental liberties. The chaos began last June the 24th, when the Supreme Court issued its decision in Dobbs versus Jackson Women's Health Organization. With a single ruling, the right-wing majority overruled 5 decades of legal precedent, revoking a constitutional right for the first time ever in the history of this nation. In the years leading up to the Dobbs decision, we were warned about the danger of overruling Roe versus Wade. Medical experts warned us it would unleash an immediate health care crisis across this nation. Legal experts warned us that it would establish a dangerous precedent in which unelected judges can deny fundamental freedoms. And women across the country warned us that overturning Roe versus Wade would insert politicians and judges into the most personal decision imaginable, and ultimately force women into continuing pregnancies that may not be viable or may endanger their lives. Tragically, all of these warnings have proven to be true. I'd like to turn to a video on the impact of the Dobbs decision.
Issuing that landmark ruling that this nation has been bracing for, and the Supreme Court has overturned Roe v. Wade, that they have eliminated the constitutional right to an abortion.
People will suffer unnecessary harm as doctors wait for permission from hospital lawyers to tell them that they can proceed. In some circumstances, the abortion care will come too late.
The fallout from the Supreme Court ruling about abortion rights is growing.
What else they can do? I mean, the states that have 12-week bans or 15-week bans want to go to 6-week or total bans altogether. So this is going to be only the beginning of the next phase.
Muzzled and shackled, that's what doctors anonymously tell CNN they are experiencing from their employers, who won't let them explain the effects of abortion restrictions to patients and the public.
It is so heartbreaking to see patients who've had to travel so far to get basic health care.
We're hearing stories all across the country of people who are in dire circumstances, complications of their pregnancies, or traumatic situations, and are needing abortion care and not able to get it.
Is it worse than you imagined?
It's worse faster.
So it was very painful, and honestly, I can't take any medicine because I still am pregnant, so I felt down into like deep depression and just was in pain all the time.
With the Dobbs decision, Justice Alito and the majority claimed that overruling Roe would finally settle the so-called controversy over abortion by returning the issue to the states and elected leaders. Well, months later, we've learned the opposite is true. The Dobbs decision didn't resolve anything. It merely replaced controversy with chaos, and it paved the way for activist judges and Republican lawmakers to try to impose their anti-choice agenda on everyone else, even in states that have protected the right to abortion. Their ultimate goal is clear: total ban on abortion nationwide. So instead of ending the debate on abortion, Dobbs was really the beginning of a different debate. How far will the war on women's health go before we say enough is enough? From the moment Roe was overruled, women and medical professionals were thrust into a sea of confusion and fear. The laws surrounding abortion and miscarriage management seem to be changing by the week, and doctors have no idea if the care they provided today will be legal tomorrow. A few weeks ago, a judge in Amarillo, Texas, issued a nationwide ruling banning one of the safest forms of reproductive care, mifepristone. It's a medication approved more than 20 years ago by the Food and Drug Administration. It is used in more than half of all abortions in America, and it is used to help women suffering from miscarriages. This medicine has a safety profile better than penicillin, Tylenol, and Viagra. Thankfully, the Supreme Court issued a temporary reprieve by staying the decision last week. So for the moment, mifepristone remains on the market as a case is considered on the merits. But the district court's judge's initial ruling marked the first time ever that a judge has overruled the FDA to ban a medication that they deem safe and effective, medical and scientific experts backing them up at our federal drug regulatory agency. It begs the obvious question, what's next? Is it going to be birth control pills? The morning after pill? Do we want to live in a country where judges and politicians replace doctors, medical experts, and scientists as the arbiters of which drugs are safe? The number of horror stories that have emerged over the past year is staggering. Stories of rape victims as young as 10 years of age being denied health care because of laws outlawing abortion. Stories of women being forced to leave their home states and travel hundreds of miles to access basic reproductive care services. Stories of pregnant women suffering miscarriages who've been turned away by doctors who, through no fault of their own, are afraid of breaking this law in this new Dobbs world. You'll hear one of these stories this morning. That's why Congress needs to step up and address this chaos. We need to respect the women's rights of women to make their own health care decisions. And we can do it by passing the Women's Health Protection Act, which would restore abortion access across America. Now the question is, will our Republican colleagues stand with the vast majority of Americans who support legal access to abortion? With that, I turn to Ranking Member Graham for his opening statement.
Thank you, Mr. Chairman. I appreciate it very much. Before we start, in 15 days, the Biden administration is going to basically do away with the ability to deport people under Title 42. There's going to be a gasoline thrown on a illegal immigration fire. People on our side are going to write the president, and we would like you to join us, if you could, to reverse this decision. Thousands of people are waiting for this moment to pass, and it's just going to create chaos upon chaos. So I request my Democratic colleagues, if you could, to join us in urging President Biden to change his mind about abandoning the Title 42 deportation. I think in a few weeks we'll see why I say this. To the topic at hand, I appreciate very much the hearing, and we'll try to do this in a very respectful way. After Dobbs, our Democratic friends are basically declaring war on the unborn. This is an emotional decision. 2/3 of Americans believe abortion should be limited after the first 3 months. And our friends on the other side have the Women's Health Protection Act, which has really no limits on abortion. There is a health care exception after viability that is no exception at all. It puts America in the company of North Korea and China that allow abortion on demand up to the moment of birth. It takes all the state level protections and abolishes them. The bottom line, it doesn't codify Roe, Mr. Chairman. It becomes one of the most extreme laws anywhere in the world. Colorado, New Jersey, New Mexico, Oregon, Vermont are passing laws with absolutely no restrictions. The Democratic bill is of the same ilk, with taxpayer funded. Let's take a look and see how that would put us as a nation regarding the rest of the world. As you see behind me, 47 of 50 European Union nations limit abortion at 15 weeks or below. France is at 14 weeks. China, North Korea, Iran, and a few other nations allow abortion on demand up to the moment of birth, and your bill would put us in that category. "14-week limitations, France, Belgium, Germany, Spain, 12 weeks, Denmark, Norway. My proposal is having a national minimum standard of 15 weeks for exceptions for rape, incest, life of the mother, pregnancies. Why do we do this? By 15 weeks, An unborn child has teeth, fingers, and toes, may begin sucking their thumb or making a fist. Each finger moves independently. Fingerprints have begun to develop fully formed organs and feel pain. If you operate on a 15-week-old unborn child, the standard practice is to provide anesthesia because the baby can feel pain. That's why 47 of 50 European Union nations prohibit abortion on demand after 15 weeks or below. Your proposal, Mr. Chairman, puts America in a category I think most Americans reject: abortion on demand up to the moment of birth, taxpayer funded, which I believe is barbaric. So what do? We're going to debate this topic. We're going to try to find consensus. But as for me, I'm going to lend my voice to the idea that America post-Dobbs should not be like North Korea and China, that America post-Dobbs should draw a line. States can take their own path up to a point. And the line I have drawn is 15 weeks, a line that puts you in association with the civilized world and rejects the barbaric practice of abortion on demand up to the moment of birth with taxpayer funding. NPR poll today said 66% of Americans support limiting abortion after 12 weeks. I don't know how long it will take, but I do believe over time, in a post-Dobbs world, Americans are going to come to a consensus on this issue. The numbers are pretty compelling for early stage abortions. Most Americans feel comfortable with a woman making that decision. But the more we learn about the unborn child, the more we understand how it develops, the more we're going to have a consensus in this country that there needs to be a point in time, Mr. Chairman, where we draw a line. Allowing abortion on demand up to the moment of birth with taxpayer funding doesn't make America a better place. It makes us an outlier in the civilized world. So I welcome the debate. It's going to be part of the 2024 election cycle and beyond. And I will close with this. This is a moment for America to have some self-reflection on a very difficult topic. Why does most of the world, particularly Europe, limit abortion at 15 weeks or under? And why would we choose to be North Korea and China on this topic? Be a debate worthy of a great nation. Thank you.
Thank you, Senator Graham, and I certainly respect your point of view, but I want to respond to it because you've made reference to a bill that I support. Here are the facts. According to the Center for Disease Control, abortions after 21 weeks make up less than 1% of all abortions in the United States. When abortions later in a woman's pregnancy happen, they can hardly be considered elective. There are three main reasons why women need access to an abortion late in pregnancy: maternal health endangerment, diagnosis of severe fetal abnormalities which did not show up until late in the pregnancy, or restrictive state laws that made it difficult for a woman to get an abortion earlier in pregnancy. The exceptionally rare cases that occur after 24 weeks are often because a fetus has a condition that cannot be treated and will never be able to survive, such as anencephaly, where the fetus forms without a complete brain or skull, or limp body wall complex when the organs develop outside the body cavity. I don't believe this is a nonchalant decision late in pregnancy. I think it's a medical emergency in many cases. And in this situation, I think the analogy to other countries and their standards does not apply. Today, we welcome 5 witnesses, and I thank them for joining us. Before we swear the witnesses in, I'll briefly introduce the Democratic witnesses, then turn to Senator Graham to introduce his witnesses. Our first witness is Amanda Zyroski. Ms. Zyroski has joined us from Texas. She is here to speak to her personal experience of being denied health care when she needed it. I'm grateful for your traveling here, Ms. Zyroski. Professor Michelle Goodwin, a Chancellor's Professor of Law at the University of California, Irvine. She also serves as the Director of the Center for Biotechnology and Global Health Policy at UCI Law. Welcome. Dr. Nisha Verma is an OBGYN in Georgia, where she provides comprehensive reproductive health care. She also serves as a fellow with Physicians for Reproductive Health. Thank you, Dr. Verma. Now, Senator Graham, your witnesses.
Thank you, Mr. Chairman. We have Dr. Ingrid Scop, is that right? She's been a practicing board-certified OBGYN physician in San Antonio, Texas for 27 years. She received her Bachelor of Science in Physiology from Oklahoma State and her medical doctorate from Washington University School of Medicine. She completed a residency at the University of Texas Health Science Center, San Antonio. She is a fellow of the American College of OBGYN Physicians, a member of the American Association of Pro-Life OBGYN Specialists. She is currently practices with OB Hospital Group and is also the Vice President of Medical Affairs for Charlotte Losner Institute. She currently serves as a medical director for Any Woman Can Pregnancy Resource Center in San Antonio, Texas, and on the medical advisory board of Save the Storks. Dr. Monique Goldenhorst, pretty good, pretty close, okay. She's a board-certified OBGYN specialist with over 20 years of experience in patient care, teaching, research, health policy, global health, and bioethics. She graduated from Mount Holyoke College and received her medical degree from Brown University. She earned a master's degree in public health from Harvard. She completed a residency at Yale New Haven Hospital and her postdoctoral fellowship in health services research at Shep Center for Health Services Research at the University of North Carolina, Chapel Hill. She's a faculty member at the Duke University School of Medicine from 2003 to 2018. She subsequently served as Senior Deputy Assistant Administrator in the Bureau for Global Health at the United States Agency for International Development. She is a Senior Research Associate at the Center for Ethics and Culture at the University of Notre Dame. Her clinical career is focused on caring for women in underserved and disadvantaged populations, especially African Americans and Native American communities, with a focus on women with medical, social, and psychiatric problems. Thank you.
Thanks, Senator Graham. Let me lay out the mechanics of today's hearing. After we swear in the witnesses, each witness will have 5 minutes for an opening statement. Then senators will have an opportunity to ask questions for up to 5 minutes. Can I ask the witnesses to please stand and raise their right hand? Do you swear or affirm the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that the witnesses have all answered in the affirmative, and our first witness will be Ms. Zyroski.
Chairman Durbin, Ranking Member Graham, and members of the Senate Committee on the Judiciary, thank you for the opportunity to testify before you today. My name is Amanda Zyroski, and I'm here to tell you a little bit about my experience with the Texas abortion bans. About 8 months ago, I was thrilled to be cruising through the second trimester of my first pregnancy. I was carrying our daughter, Willow, who had finally, blissfully been conceived after 18 months of grueling fertility treatment. My husband, Josh, and I were beyond thrilled. Then, on a sunny August day, after I had just finished the invite list for the baby shower my sister was planning for me, everything changed. Some unexpected symptoms arrived, and I contacted my obstetrician to be safe and was surprised when I was told to come in as soon as possible. After a brief examination, my husband and I received the harrowing news that I had dilated prematurely due to a condition known as cervical insufficiency. Soon after, my membranes ruptured, and we were told by multiple doctors that the loss of our daughter was inevitable. It was clear that this was not a question of if we would lose our baby, it was a question of when. I asked what could be done to ensure the respectful passing of our baby and to protect me now that my body was unprotected and vulnerable. I needed an abortion. My healthcare team was anguished as they explained there was nothing they could do because of Texas's anti-abortion laws, the latest of which had taken effect 2 days after my water broke. It meant that even though we would, with complete certainty, lose Willow, My doctors didn't feel safe enough to intervene as long as her heart was beating or until I was sick enough for the ethics board at the hospital to consider my life at risk. I shouldn't have had to wait in anguish for days for the inescapable ill fate that awaited. But this was August 2022 in the state of Texas, where abortion is illegal unless the pregnant person is facing a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy. People have asked why we didn't travel to a state where the laws aren't so restrictive. But we live in the middle of Texas, and the nearest sanctuary state is at least an 8-hour drive. Developing sepsis, a condition that can kill in under an hour, in a car in the middle of the West Texas desert or on an airplane, is a death sentence. And it's not a choice we should have even had to consider in the first place. So all we could do was wait. I cannot adequately put into words the trauma and despair that comes with waiting to either lose your own life, your child's, or both. For days, I was locked in this bizarre and avoidable hell. Would Willow's heart stop, or would I deteriorate to the brink of death? The answer arrived 3 long days later. In a matter of minutes, I went from being physically healthy to developing a raging fever and dangerously low blood pressure. My husband rushed me to the hospital, where we soon learned I was in septic shock, made evident by my violent teeth chattering and incapacity to even respond to questions. Several hours later, after stabilizing just enough to deliver our stillborn daughter, my vitals crashed again. In the middle of the night, I was rapidly transferred to the ICU, where I would stay for 3 days as medical professionals battled to save my life. What I needed was an abortion, a standard medical procedure. An abortion would have prevented the unnecessary harm and suffering that I endured. Not only the psychological trauma that came with 3 days of waiting, but the physical harm my body suffered, the extent of which is still being determined. 2 things I know for sure. The preventable harm inflicted on me has already made it harder for me to get pregnant again. The barbaric restrictions that are being passed across the country are having real-life implications on real people. I may have been one of the first who was affected by the overturning of Roe in Texas, but I'm certainly not the last. More people have been and will continue to be harmed until we do something about it. You have the power to fix this. You owe it to me and to Willow and to every other person who may become pregnant in this country to protect our right to safe and accessible health care, emergency or no emergency. No one should have to worry about the life of their loved ones simply because they are with child. Your job is to protect the lives of the people who elected you, not endanger them. Being pregnant is difficult and complicated enough. We do not need you to make it even more terrifying and, frankly, downright dangerous to create life in this country. This has gone on long enough, and it's time now for you to do your job, your duty, and protect us. Thank you.
Dr. Scop, please proceed.
Thank you, Chairman Durbin, Ranking Member Graham, and members of the committee. As you've heard, I am Dr. Ingrid Scop, a board-certified obstetrician-gynecologist practicing in Texas for over 30 years. Today, I advocate for both of my patients, a woman and her unborn child. Every successful abortion ends the life of one of my patients and often harms the other as well. In the coming legislative session, Senator Graham will likely reintroduce federal minimum protections limiting elective abortion after 15 weeks gestation, with exceptions for rape, incest, and the life and health of the mother. Conversely, Senator Baldwin has reintroduced the Women's Health Protection Act, which ironically does nothing to protect the health of a pregnant woman from a dangerous abortion. The unborn human life is never acknowledged, and abortion is presented as procedurally and morally equivalent to a vasectomy or a colonoscopy. This proposed legislation insists that there can be no common sense safeguards to protect a woman. The words choice, voluntary, and consent are completely missing, opening the door to others who will benefit from abortion: sex traffickers, incestuous abusers, and unwilling fathers. An abortion provider is not required to be a physician or even medically licensed. Despite its euphemistic name, the Women's Health Protection Act prioritizes the death of the unborn human at the expense of the health or even the desires of a pregnant woman. A woman and her unborn child are not natural enemies. Most pregnancies end in delivery of a healthy baby to a healthy mother. Media sources have misinformed the public, alleging that abortion limits will prevent an obstetrician from providing necessary medical care, increasing maternal mortality, but this is not true. Every legal restriction protecting unborn life allows a physician to use his reasonable medical judgment, that is, to follow the standard of care to determine when to intervene in a medical emergency. Let's compare how second trimester limitations versus unlimited abortion throughout pregnancy will actually impact American women. 90% of abortions in the second half of pregnancy are obtained for the same reasons as early abortions, social and financial concerns. Additionally, there are other important factors, coercion and indecision. 9 months is a long time for a woman who desires her child to say no to a coercive partner. Decisional uncertainty leaves the woman likely to regret aborting a baby whose kicks she can feel and with whom she has begun to bond. The physical risk of abortion increases as pregnancy progresses. The risk of maternal death is 76 times higher in the second half of pregnancy compared to an early abortion. The dilation and evacuation procedure used for most later abortions involves forcing open a strong muscular cervix and blind insertion of sharp instruments to dismember and extract a struggling fetus, and may cause hemorrhage, cervical damage, retained tissue, and uterine perforation. Mental health complications, including anxiety, depression, suicide, and substance and alcohol abuse, are higher after abortion, particularly after late or coerced abortions, or if there are pre-existing mental health issues. European records linkage studies document a woman has 6 times the risk of suicide in the year following an abortion compared to childbirth. Unfortunately, the U.S. Centers for Disease Control does not even attempt to link mental health deaths to abortion in its dramatically incomplete maternal mortality data. Americans intuitively recognize these risks, as 3/4 support a limitation at 15 weeks, and only 1 in 10 support abortion without gestational limits. Extremely late abortions are sometimes performed by labor induction because the fetus has grown too large to easily dismember. European studies document over half of babies survive induction abortion, and 69% of U.S. late-term abortionists report they do not routinely kill the fetus first. So it is likely that many babies survive late abortions and then are passively or actively killed. Infanticide used to be a red line, but no longer, as legislative protection for these unfortunate children has repeatedly been rejected. Fetal neurologic research documents that the pathways required for pain perception are in place by 15 weeks gestation, and during an abortion, the fetus displays all the responses that we too would exhibit if we were torn limb from limb. I have cared for many tiny babies, delivered at the edge of viability around 22 weeks. Their precious faces express pain when their fragile bodies undergo therapeutic procedures. Fetal surgery as early as 15 weeks can be performed to heal some neurologic and vascular disorders before birth. Of course, these babies are always offered pain relief. How can we justify painful dismemberment of unborn babies at similar gestational ages just because we cannot hear their cries? Thank you.
Professor Goodwin.
Committee Chairman Durbin, Committee Ranking Member Graham, and distinguished members of the Senate Judiciary Committee. My name is Michelle Goodwin, and I am a Chancellor's Professor at the University of California, Irvine, and the Abraham Panansky Visiting Professor at Harvard Law School. In its 2021-2022 term, the United States Supreme Court decisively undercut stare decisis and the rule of law when it overturned Roe v. Wade and Planned Parenthood v. Casey. In doing so, the Supreme Court unleashed a torrent of unnecessary uncertainty, fear about the future of protections for women's health and their rights to life, liberty, and safety. Justice Thomas's concurring opinion placed all privacy rights on high alert, save for interracial marriage, a status enjoyed by the justice himself. For all other privacy rights, including marriage equality, access to contraception, freedom from state-imposed sterilization, and more, his concurrence remains a cause for serious alarm. Despite the promised protections articulated by the majority and Justice Kavanaugh, that freedom of travel would be preserved and that its dismantling of Roe would return abortion rights to the states, today some legislatures are seeking to dispossess citizens of access to the ballot, whether by enacting provisions making it more difficult to vote or engaging in efforts to rewrite states' laws related to ballot initiatives and referenda, thereby introducing anti-democratic principles into the democratic process itself. The post-Dobbs era exposes not only a cruel disregard for the lives of those most affected, but also a lack of regard for constitutional law and foundational principles and values such as freedom of movement, freedom of speech, freedom of association, privacy, and separation of church and state. In the aftermath of Dobbs, women, girls, and people with the capacity for pregnancy are more at risk of state-level criminal and civil surveillance than before, whether in the effort to track their menstruation and travel. The Bill of Rights, once proudly championed by our government because it protected speech, because it protected bodily privacy, because it protected freedom from government overreach, including cruel and unusual punishment, it too now is vulnerable. Understandably, women and girls who do not wish to become pregnant, are not prepared for motherhood, or whose health is placed at risk by pregnancy and miscarriage are horrified, absolutely horrified, about credible present dangers and those that lurk ahead. The United States bears the worrying distinction as, quote, the deadliest nation in the industrialized or developed world to be pregnant. This is what barbarism looks like. This is what cruelty looks like. Nationwide, as noted by Justice Breyer, childbirth is 14 times more likely than abortion to result in death. I'll repeat that. Childbirth is 14 times more likely to result in death than by abortion. As reported by Nina Martin and Renee Montaigne, more American women are dying of pregnancy-related complications than any other developed country. In fact, only in the U.S. has the rate of women who die during pregnancy risen. As research from the Texas Observer shows, and my prior scholarship explains, this trend maps with the destructive anti-abortion legislating and dismantling that has gone on in our country, exacerbated between 2010 and 2013, and now in just rapid exhilaration. More recently, data show that the U.S. maternal mortality crisis has worsened in the period overlapping with COVID-19 and as well in the period since Dobbs itself. Today, you'll hear more about these matters from me. Let me just say that as I close, this period of time since Dobbs has unleashed criminal actions against women and their doctors. It has also unleashed civil surveillance, the type of which includes in Nebraska, a mother and her daughter being criminally pursued. In Texas, doctors facing a $100,000 fine and 99 years incarceration should they try to help a patient terminate a pregnancy. In Louisiana, a woman being forced to gestate a fetus that had no skull development. In Wisconsin, a woman needing to bleed nearly to death before her doctors could intervene. And as you mentioned, Senator Durbin, right after Dobbs, the case of a 10-year-old girl having to flee Ohio to get to the state of Indiana in order to terminate a pregnancy due to rape. Thank you so much.
Dr. Goldenhorst.
Chair Durbin, Ranking Member Graham, and members of the committee, thank you for your invitation to and the opportunity to testify at this hearing. My name is Dr. Monique Goldenhorst. I am a practicing board-certified OBGYN with more than 30 years' experience in patient care, teaching, research, health policy, and global health. I'd like to begin by noting that the Dobbs decision presents an opportunity to mitigate abortion's many harms to women, unborn children, families, and community. Abortion not only poses risks to the mother, it is also, by definition, always lethal to an embryo or fetus, an unborn child who is a human being, a member of the human family. not a clump of cells or a potential child, but a child assuming the human form. Abortion's goal is to kill that human being. It neither treats, palliates, or prevents any disease and is therefore not health care. This is reinforced by the fact that the majority of OBGYNs do not perform abortions. Studies show that the percentage that do is declining and has been for decades, from a high of 40% in 1985 to between 7 and 24% at present. Given this, abortion cannot be considered essential health care for women, and if abortion is health care, my question is, what disease are you treating? Clinicians caring for pregnant women have two patients. Advancements in technology have allowed us to recognize the fetus as the patient within the patient. If the unborn child was not human, this investment in research and clinical care would not have occurred. But that view changes only if the same child is unwanted by his or her mother. And the current emphasis on dilation and evacuation in the second trimester really arises from a eugenic view of abortion. It's a recognition of it's an admission that the fetus is not truly a human being and ignores the fact that fetuses do experience pain at earlier gestational ages. Most abortions are elective. The bar for safety should be very high, and there's evidence that the safety of both medical and surgical abortion is overstated. As noted earlier by my colleague, the risks of abortion increased dramatically. Bartlett et al. In 2004 found that the risk of a woman dying from abortion, not experiencing complications but dying, increased 38% for each week of gestational age. Abortions performed past 21 weeks had a mortality rate 76 times greater than abortions done in the first trimester. Abortion does not prevent pregnancy complications or reduce maternal mortality. A woman's individual risk for pregnancy complications such as diabetes, even mortality, is estimated but cannot be predicted with certainty. There's no way to predict whether an individual woman will suffer a pregnancy complication, and any presumed effect of abortion on maternal mortality is speculative and based on statistical sleight of hand. It does not address causes of maternal mortality, in particular cardiovascular disease and infection. The women who in the United States who are at the highest risk for adverse pregnancy outcomes, mostly African American women, are in fact, from the eugenic viewpoint, the unfit. The early eugenicists made similar arguments, proposing contraception and sterilization as solutions to medical and public health problems. Therefore, we must consider that the effective public health measures and medical treatment, patient education that are needed to improve maternal outcomes are the real answer to maternal mortality, not abortion. For pregnancies where serious complications occur, early delivery of the unborn child may be necessary, but such a delivery is not an abortion because its goal is to save the life of the mother and the life of the fetus, if possible. This is ethically permissible. As in law, in medicine, intent is paramount. Premature delivery is not induced abortion, according to the American Association for Pro-Life OBGYNs, and the Dublin Declaration upholds that there is a fundamental difference between abortion and necessary medical treatments that are carried out to save the life of the mother, even if such treatments result in the loss of her unborn child. Since Roe v. Wade, an estimated 17 million unborn African Americans have been aborted in the United States, which is more than the populations of the countries of Senegal and Cambodia, respectively, and slightly less than the entire population of the Netherlands. This means the deaths of not only the 17 million black people who were aborted, but all their descendants, their families, hopes, and dreams. Annually, approximately 300,000 black women undergo abortion every year, while in 2021 there were approximately 518,000 births to black women, a number that continues to decline. We must ask ourselves, how is this destruction of innocent life reproductive justice? How does one defend the deliberate killing of the most vulnerable members of minority group, especially when births to that group have been and continue to be in decline? Rather than black women achieving bodily autonomy and controlling their fertility, instead their fertility is being controlled. There are substantial racial disparities in abortion rates, abortion mortality, and non-abortion related maternal mortality between black and white women. 38% of abortions occur in black women, a rate which is 2 to 3 times higher than that of white women, even though we comprise only 12 to 14% of the total U.S. population. An estimated 684 black children are aborted every day. African American women also have a 2 to 3 times higher mortality from abortion compared with white women. Therefore, black women have the highest rates of abortion and the highest rates of maternal mortality. Both of these facts cannot be true if abortion reduces maternal mortality. In conclusion, the medical, public health, and social landscape post-Dobbs offers many opportunities to help and support women to carry their unborn children to term. These include pregnancy resource centers, programs to improve maternal health, interventions to treat unborn children with disabilities, as well as perinatal hospice, and stronger civil society engagement in the mission of strengthening families. The pro-life message is one of profound hope and healing, of love and encouragement, of walking with women and parents and families through often difficult circumstances and helping them to thrive. Thank you for your invitation to this hearing. I look forward to your questions.
Dr. Verma?
Good morning, Chairman Durbin, Ranking Member Graham, and distinguished members of the Senate Judiciary Committee. My name is Dr. Nisha Verma, and I am a board-certified, fellowship-trained obstetrician and gynecologist providing full-spectrum reproductive health care. That means I do everything from cancer screenings to delivering babies to supporting people as they decide to continue or end a pregnancy. I am a fellow with Physicians for Reproductive Health, and I'm also a proud Southerner. I was born and raised in North Carolina. I currently provide care in Georgia, and I've lived in the Southeast for most of my life. I decided to stay in Georgia after the Supreme Court overturned the constitutional right to abortion care, and Georgia enacted a law that bans most abortions in our state last year. I decided to stay knowing Georgia's law threatened to make me a criminal for providing life-saving care to my patients, because I made a commitment when I became a doctor to serve my home and my community in the South. But every day, Georgia's law forces me to grapple with impossible situations where state laws directly violate the medical expertise I gained through years of training and the oath I took to provide the best care to my patients. Because of a law that is not based in medicine or science, I am forced to turn away patients that I know how to care for. I've had adolescents with chronic medical conditions that make their pregnancies very high risk, women with irregular periods who don't realize they're pregnant until after 6 weeks, and couples with highly desired pregnancies who receive a terrible diagnosis of a fetal anomaly, cry when they learn that they can't receive their abortion in our state, and beg me to help them. Imagine looking someone in the eye and saying, "I have all the skills and the tools to care for you, but our state's politicians have told me I can't." Imagine having to tell someone, "You are sick, but not sick enough to receive care in our state based on our law's very narrow exceptions." Abortion is extremely safe, and none of the arbitrary barriers imposed by politicians make it any safer. In fact, the National Academies of Sciences, Engineering, and Medicine published a comprehensive study affirming the safety of abortion and pointed out that the biggest threat to patients is medically unnecessary restrictions. One of my patients, I'll call her M, gave me permission to share her story with you all today, and her experience brings the findings of this study to life. She struggled with infertility, and she and her husband were thrilled to see the positive pregnancy test after they transferred their final embryo. Then, at 17 weeks, when there was no chance of her baby ever developing lungs that would allow it to live outside of her, her water broke. She went to the hospital, but because her baby still had a heartbeat, her doctors couldn't do anything to help her. Instead, she had to wait to get sick, to start bleeding heavily or develop an infection of her uterus that could spread into her bloodstream. M shared with me that to be denied the basic medical care I needed, to be told that I must first be at risk of dying, to be forced to relive the trauma of losing my baby every day for 5 days because of Georgia's law. The trauma of that on top of my loss is devastating. She told me her baby's name was Ezekiel Charles, which means God's strength, and that she would miss him at every major and minor milestone he would have had in his life. I stayed in Georgia to provide care for people in my community, but my heart breaks every day for my patients like M as I bear witness to the pain they have to carry because of these restrictions on abortion access. We know from recent data that already thousands of people have been forced to remain pregnant and have faced harm like developing serious medical conditions as a result. And we know that states with higher numbers of abortion restrictions are the same states with worse maternal health outcomes, with marginalized populations facing the largest burden. Already, the U.S. has the highest maternal mortality rate of all high-income countries in the world, and data from the CDC shows us that this crisis is only worsening. I understand that abortion care can be a complicated issue for many people, just like so many aspects of healthcare and life can be. But I also know that abortion is necessary, compassionate, essential health care, and that my patients are capable of making complex, thoughtful decisions about their health and lives. No law should prevent them from doing so. I am unwavering in my commitment to support people in my home in the South. It shouldn't have to be this way. I urge you to listen to the stories of people who provide and access abortion care. I hope these stories help you understand that abortion care is not an isolated political issue, and to see how profoundly restrictions on abortion access harm all of our communities. Thank you for having me today, and I look forward to your questions.
Thank you, Dr. Berman. Thank you to all of the witnesses. Ms. Zyroski, I can't remember testimony as compelling or as forceful as yours. I do this for a living. When I heard your story as you presented it, I thought for a moment, what would I feel like if you were my daughter going through this? The joy of a possible grandchild that's been erased, and now you struggling to live, and an arbitrary political obstacle to saving your life. At some point, you had to be so sick and near death before they finally would agree to terminate the pregnancy. As you listen to the testimony from witnesses who share your feelings and don't, what was your reaction?
It's a good question. It's very complicated. As Dr. Verma said, everything about abortion is complicated. I understand that. It gives me a lot of hope to know that there are people like you and like some of my fellow witnesses who are fighting for safe and accessible health care. But it's also infuriating to know that there are people who think that what happened to me was okay, and that it should have happened, and that it should continue to happen.
Once again, your answer is direct and has great meaning for me personally, I hope for others. I'd like to ask Dr. Scop a question. Based on your profession and medical expertise, with a reasonable degree of medical certainty, tell me when life begins.
96% of biologists agree, and I agree, and this is scientifically proven, that life begins at the time the sperm fertilizes an egg to create a zygote, which is the first stage in the process of human life.
So the termination of a pregnancy is the taking of life at any stage after the moment of conception?
The legal definition of abortion is an action performed with the intent to end the unborn human life.
So is the answer the affirmative?
Yes, sir.
Do you support Senator Graham's bill?
I'm here today in the capacity as a clinician and as a researcher. And as I've stated in my testimony, I think there are many reasons to support Senator Graham's bill based on the effects that late-term abortions have on women, which I have noted in my practice can be devastating, particularly the case that many of these women are coerced into these abortions.
I'm not at that level. I'm trying to stick to the original question. But it's my understanding that if you believe an abortion occurs when pregnancy is ended after the moment of conception, then the notion of his bill limiting abortion to 15 weeks suggests that would be the taking of a human life for 15 weeks after birth. Is that correct?
I understand what you're saying, and there is a difference between what is politically feasible and what is morally defensible. And I think our country does need to have a conversation about the reasons that we are taking human life.
In my mind, this gets to the heart of the issue and the debate. When does life begin? The debate has been going on for a long period of time, maybe from the beginning of civilization. I'm not sure I have the right answer. I'm not sure Dr. Scop has the right answer. We're trying to find a humane response. When I listen to Ms. Zyroski, I understand if you start from the moment of conception and say that she has to weather what she did, literally at the brink of losing her life before you could end that abortion, you have to ask yourself, what about the life of the mother? Is that a critical element too? I think it is. Professor Goodwin, you talked about what women are going through now with data privacy and the possibility that they're going to be tracked as to whether they visit an abortion clinic and penalized by their home state. Is that a possibility?
It is a possibility, and already in the state of Idaho, there's legislation moving forward to track whether people would leave the state and travel. What we see is the dismantling, the vulnerability of constitutional principles that date back centuries, and abortion is being used as a proxy to dismantle fundamental constitutional principles, including the right to travel.
Dr. Wilberhorst makes a point about the number of African-American women who are seeking abortions. Would you like to respond to that?
Yes, I would. Senator Durbin, in the state of Mississippi, a Black woman is 118 times more likely to die by carrying a pregnancy to term than by having an abortion. The state of Mississippi has notoriously been a death sentence for Black women dating back to the time of slavery, through Jim Crow, and to the present. And if we don't thread that needle together, then there's a lot that we are missing. There is a reason why Black women in Mississippi have sought to be able to terminate pregnancies for their own bodily autonomy, for their own safety, for their own health. Mississippi is one of the deadliest places, not just in the country to be pregnant, but it's one of the deadliest places in all of the industrialized world to be pregnant. And right now, as there are anti-abortion measures being spread through what was the U.S. Confederacy, what we see are the people who are most harmed were the people most harmed during American slavery and Jim Crow too, and that happens to be Black women.
Thank you, Professor. Senator Graham.
Thank you. Very interesting discussion, and I think we need to put it in context of where the world's at. Dr. Stop, is that right? Are you from Texas?
I am from Texas.
Amanda's situation was terrible. What happened in Texas?
You know, Amanda, I want to say I am so sorry at your loss of Willow, and I am so sorry that your doctors misunderstood Texas law. I've reviewed Texas law, of course, because I practice there and I want to understand, as well as all of the other laws in the states. Every single law allows an exclusion for a doctor to use their reasonable medical judgment to determine when to intervene in a medical emergency, which is usually defined as a threat to the life of the mother or permanent irreversible damage to an organ or an organ system. None of the states have the terminology that the threat must be immediate. Doctors know, and we obstetricians have always known, even prior to Dobbs, the Hyde Amendment has been in place since the late 70s, and the Hyde Amendment allowed an exclusion for life of the mother. So doctors have been practicing, and I have not changed my practice in any way since the Dobbs decision. The American College of Obstetrics and Gynecology, in regards to the horrible situation that Amanda found herself in, pre-viable, premature rupture of membranes, where the water bag breaks, but labor does not ensue, and the baby is a long way from being able to live outside of the mother. The American College acknowledges that the risk of infection is high, which can become sepsis, which can threaten the mother's life. The likelihood that the baby can make it to an age in which it can live outside of the uterus is very low. And they tell us, and obstetricians do follow ACOG's recommendations for the standard of care. They tell us at the time of diagnosis that we should offer immediate termination of pregnancy, which they define as induction or dilation and evacuation abortion, or expectant management. So in a woman who is not currently infected and sick, I have had patients who have wanted to stay pregnant in hopes that they could get the baby to a gestational age where it could live. But it has always been the standard of care and continues to be the standard of care to offer delivery at that time. Most of my patients have opted for induction rather than D&E because they wanted to have a baby to mourn. But either one could have been offered and should have been offered to Amanda.
Thank you. 15 weeks is it fair to say that baby has a heartbeat at 15 weeks? Does anybody on the panel disagree with that? As a matter of fact, the baby has a heartbeat about 2 months before 15 weeks. Is that right, Dr. Stoke?
23 days after conception, there's a muscular chamber innervated by electrical impulses pumping blood cells, which are oxygenated throughout the baby's body.
Does anybody disagree with what I said about the European standard that 47 of 50 European nations limit elective abortion at 15 weeks or less? Does anybody disagree with that? Good. The bottom line is 55,000 babies are aborted after 15 weeks in the United States. Is that right, Dr. Verma-Hurst?
That's correct.
And most are elective, so this would matter. So I'm for my bill. I'm not asking you to be, Dr. Stoop, but I'm for it. Let me tell you why I'm for it. I'd like America at some point in time to say, 15 weeks being pretty good to me, that a baby is well developed, can feel pain. You can't operate on the baby medically without anesthesia because the baby can feel pain in efforts to save its life, to draw a line. There's nothing unreasonable about trying to draw a line at 15 weeks when 47 of 50 European nations do that, with exceptions for rape, incest, life of the mother. What's unreasonable is allow abortion on demand up to the moment of birth. That's exactly what your bill does. That puts you in the category of China and North Korea. I welcome this debate. We're not going to back off. We're going to try to have America in line with the civilized world, not North Korea and China. Nothing good comes from wholesale abortion on demand at 15 weeks when the baby can feel pain.
Senator Whitehouse.
Thanks, Chairman. Welcome to the witnesses. One of the things I noticed about the Dobbs decision was that in order to get where the justices in favor of that decision wanted to go, they had to change the legal standard from a balancing of interests to history and tradition. In a balancing of interests, one of the interests is the interest of the woman involved in the procedure. In history and tradition, you go back to ancient history, before women had rights, like the right to vote, like the right to have credit without the permission of their husband. It looked like the rights of women were being deliberately removed from the equation by the justices of the Supreme Court. And in that context, Ms. Zyroski, how did it feel to you? How did you feel that your rights, your interests were being considered as you went through the experience that you had to?
I felt I had absolutely no right to make a decision for my own body, for my own health, for the health of my child. I thought about when my grandfather was in the hospital, similarly also had sepsis, and my dad and his siblings were making the decision on how he should receive healthcare and what kind of treatment he should receive. And what I couldn't understand in those 3 days where I had to sit and wait to get healthcare is how is it that my dad was able to make healthcare decisions for his dad, but I couldn't make my own healthcare decisions for myself and for the child that was inside me. I had no right, I had no opportunity, and neither did my healthcare team.
In addition to changing the legal standard to get the result they wanted, the other thing that stuck out for me in that decision was Justice Alito's language that Roe versus Wade, and I'll quote him here, was egregiously wrong from the start. So presumably that means the start back in 1973. Well, after that start, while Roe was egregiously wrong, Alito came before this committee. And he had the chance to tell us that he thought Roe was egregiously wrong, make that observation about that case, and instead he hid that sentiment. He said instead, Roe versus Wade is an important precedent of the Supreme Court. It was decided in 1973, so it has been on the books for a long time. It is a precedent that has been on the books for several decades. It has been challenged. It has been reaffirmed. No egregiously wrong. Everything designed to reassure us that he was not going to overturn that decision. So looking back, he looks a lot like a sleeper agent predetermined to attack Roe, who wouldn't disclose what he was up to until he had the majority that he needed to change the legal standard and destroy the legal precedent. I think it's a very unfortunate episode in the Supreme Court's history. Dr. Verma, one of the groups I've heard the most from about this in Rhode Island has been OBGYN doctors who express real horror at what this means for their practice, particularly in circumstances where a pregnancy has begun to go wrong, where there are very difficult decisions that have to be made that balance the life of one fetus against perhaps another if it's twins, against risk to the mother. And in that context, they view these laws as forcing decisions and disabling them from making decisions that are customary medical practice. Could you comment on that and what some of the circumstances are that you consider to be most dangerous with regard to these laws?
Absolutely. Thank you for that question. I can tell you as the OBGYN on this panel who provides full spectrum care, including labor and delivery and abortion care, that these laws are creating huge amounts of confusion on the ground and preventing people from accessing the health care that they need. We train for years and years to be able to look at the person in front of us and to make the best healthcare decisions with them and their families. And we're seeing that many people with high-risk pregnancies are not able to get the abortion care that they need. You've heard a couple examples of people that break their water before the baby's able to survive outside of them. I also take care of people with medical conditions like really high blood pressure, where continuing the pregnancy puts them at risk for things like stroke and preeclampsia. We see people with peripartum cardiomyopathy, where the pregnancy causes their heart to enlarge and weaken, and the risk of having that happen again in another pregnancy is quite high. For all of these people, we're having to ask ourselves, how sick do they have to get to be able to intervene? Instead of just being able to provide the best medical care for the person in front of us, we're having to figure out, can I do this under the law? And that's creating huge amounts of confusion and absolutely preventing people from getting the care that they need.
Thanks, Mr. Chairman. I'd like to ask unanimous consent to let statements from some of Rhode Island's OBGYN doctors be admitted into the record.
Without objection. Senator Cornyn.
Dr. Scop, if I understood you correctly, you said that in your medical opinion that the way Amanda's doctor handled her pregnancy was a deviation of the standard of care in similar cases. Did I understand you correctly?
ACOG tells us on when it's appropriate to offer delivery.
Well, back many years ago, I used to handle medical malpractice cases, and usually when a medical expert says that what a doctor did violated the standard of care, that gave rise to a cause of action for medical malpractice. I was just curious about that. So this is an emotional and divisive issue. There's no doubt about it. That's a statement of the obvious. I appreciate, Dr. Scop, you're pointing to the difference between what is moral, which is an individual decision people make about appropriate conduct, and then what is possible. when it comes to building consensus, either among the American people or the people in a given state or in the legislative branch. But I can pretty much guarantee that post Roe versus Wade, now that that issue is back in the hands of the state legislatures, it's highly unlikely there will be a federal abortion standard. It requires 60 votes in the United States Senate. And as you can see, this is a very divisive issue. But I want to ask you, again, Dr. Scop, I'm just going through the Women's Health Protection Act. This is what's been offered by Senator Baldwin and her Democratic colleagues as an alternative to states determining what the abortion laws should be. First of all, can you tell us who Kermit Gosnell was?
Yes, Kermit Gosnell was a obstetrician in inner city Philadelphia who for 17 years, his clinic was never inspected by the Pennsylvania State Department of Health. He was allowed to perform very unsupervised late-term abortions on unfortunate, poor minority women. And when it was actually, I believe a pill mill through which the state started investigating him, but it was determined that there were women who had died under his care, that his clinic was very squalid conditions. There was evidence that babies had been born alive, and then he committed infanticide, and he is currently serving time in prison. He's an example of what happens if we allow politics to keep us from supervising abortion providers to make sure they're performing adequate care. And unfortunately, under this legislation, we may see more providers like that.
Well, there's a cottage industry here in Washington, D.C., naming legislation in ways that are the opposite of how they actually function. I'm thinking of the Inflation Reduction Act, which didn't actually reduce inflation, for example, but this legislation that Senator Durbin and others are proposing is so-called the Women's Health Protection Act. If it were more accurately named, it seems to me it might be the Kermit Gosnell Tribute Act, because it would eliminate all restrictions at the state or federal level on access to abortion. The bill text says it supersedes and applies to all federal and state laws, and that no law in conflict with this shall be enforced. It allows the access to abortion through all 9 months of pregnancy, including late-term abortions. It doesn't speak to infanticide, but we can imagine what would come next. The Hyde Amendment, which you alluded to, which has provided for many years now, since the 70s, that no tax funds, no taxpayer funds could be used to fund abortion, would be overruled. All parental consent and parental notification laws, if your adolescent child became pregnant, you would have no right to know of their seeking access to abortion, or certainly no right to consent. If someone wanted to get an abortion because they had a female baby and they wanted a male child, this proposed law would overrule that restriction and allow sex selection abortion. I could go on and on and on, but I don't believe that the proposal that Senator Durbin and his Democratic colleagues have made represents the consensus in this country. We all have a right to our own moral judgments, but when it comes to the laws of the land, no one has a right to impose their personal views on everyone else, which is what Roe versus Wade did. The Supreme Court took that out of the discussion among the American people or the halls of Congress or the state legislators, and said that you could not pass a law, regardless of where the consensus was, effectively allowing abortion on demand through till the time of delivery. So we need to solve this problem. but we're not going to solve it in Congress. This is now being debated, should be debated, and be resolved in the state legislatures around the country. Thank you, Mr. Chairman.
Since the senator from Texas mentioned my name several times, I'd like to make a point for the record. In 2013, Dr. Kermit Gosnell, a physician in Pennsylvania, was found guilty on 3 charges of infanticide, murdering babies born alive in his clinic after botched late-term abortions. Gosnell was also found guilty of involuntary manslaughter in the death of a woman who was undergoing an abortion in his care. He was sentenced to life in prison without the possibility of parole. I might remind the senator that this happened while Roe versus Wade was the law of the land. To suggest that it somehow would absolve that kind of conduct is just plain wrong.
Thank you, Mr. Chairman. You don't need to remind me.
Senator Klobuchar.
Ms. Zyroski, thank you for sharing your difficult story with all of us today. As you know, nearly half the states in the country have now enacted restrictions or are moving toward bans. 12 states are enforcing near total bans on abortion. In your testimony, you say that traveling to another state for care was not an option for you because you would have had to drive 8 hours and risk what you called the death sentence of developing sepsis, which can kill quickly in the middle of the West Texas desert or 30,000 feet above the ground. What do you want people to know about the risks that bans and restrictions place on women experiencing miscarriages?
Thank you for that question. So first, I'd like to revisit something that Senator Cornyn brought up in Dr. Scop's response, because I'd like to make it clear that Dr. Scop is not my physician. She has never been my physician. She's never treated me. She has not seen my medical records. Quite frankly, my physician and my team of healthcare professionals that I saw over the course of 3 days while I was repeatedly turned away from healthcare access made the decision to not provide an abortion because that's what they felt they had to do under Texas's law. And that will continue to happen, and it is continuing to happen. And it's not a result of misinterpretation. It's a result of confusion. And the confusion is because the way the law is written, the language in the law is incredibly vague, and it leaves doctors grappling with what they can and cannot do, what health care they can and cannot provide. And if they make the wrong decision, they face up to 99 years in prison and or losing their license. And in my opinion, that was intentional, because after the Dobbs decision, the administration put out guidance for when an abortion can and cannot be, or should not be provided. And the state attorney general in Texas, Ken Paxton, hated that so much that he sued the government to overturn those guidelines. And so what happened to me is exactly what he wanted to happen.
And your point is that right now we have a patchwork of laws across this country. And if we would enact some federal standards here and codify Roe v. Wade into law, which was the law of the land before this, this wouldn't have happened to you.
That's right.
Okay, thank you. Dr. Verma, how do the medical consequences of delaying care impact women?
They impact women significantly. We are seeing, I am practicing in Georgia where we have a 6-week ban in place, and we're having to turn away patients for all kinds of reasons. People that have irregular periods that don't realize they're pregnant until after 6 weeks, people that are diagnosed, their babies are diagnosed with terrible fetal anomalies on their 20-week ultrasound, people that develop worsening medical conditions during their pregnancies. And because they can't access their care in our state, even though their doctors are trained to provide that care, they're having to figure out if they can go out of state, get the resources together, take time off work, figure out childcare.
And what impact would a national ban on mifepristone have on your ability to care for your patients?
It would have a devastating impact on our ability to care for our patients. We know based on decades of evidence that mifepristone is incredibly safe and effective and can be used in combination with misoprostol for both medication abortion and management of miscarriages. It's an incredibly important treatment for our patients to have available to them.
You know, since Dobbs, states like Minnesota and Illinois have become islands of care in the middle of the country. We are the states that are the islands of care. In 2022, Whole Women's Health of Minnesota in Bloomington saw the percentage of out-of-state patients that they treated increase to more than double the numbers in 2019. Since Dobbs, have you seen influxes in patients coming, going between states to access care?
Absolutely. We're seeing patients trying to get out of state to get the care that they need, although we also know that many people are not able to do that and are being forced to continue pregnancies that put their health at risk, that are being forced to deliver because they don't have the resources to get out of state.
Okay, thank you. I'm going to ask one question in my remaining time of you, Professor Goodwin. One judge in Amarillo and two on the Fifth Circuit would have entered an injunction setting limits, saying you cannot receive mifepristone by mail, you can't get it over the counter in the pharmacy, that they're going to have it be available not in to 10 weeks, but 7 weeks instead. And as you know, that's currently on hold. And one of the things the Justice Department argued was that the doctors who brought this case, unlike the American Medical Association, that's made it very clear that this drug is safe and it's been used in 60 countries over 23 years in America. The Department of Justice, those few doctors that brought this case, argued that the Department of Justice said they should not be able to sue because they hadn't been impacted by the approval of mifepristone, and they were not going to be impacted in the future, unlike someone say that we've just heard from in Ms. Zyroski. So I thought this was interesting because, as you know, Justice Scalia has made similar comments to this where he rejected a lawsuit saying it would make a mockery of our prior cases, that basically you wouldn't have the standing to bring a case when you haven't had harm or expect to have harm. Quickly, do you want to comment on that and what standing really means and why this case should fall on the standing of those that brought it?
The case itself was absurdist. What the petitioners claimed was that the FDA had rushed to judgment with approving this drug. That drug spent over 54 months of review. 2000, it came into the marketplace. Other drugs that were approved in that same period had spent 15 months of review. What we know is that it's safe. It's a drug that had already been used in Europe, and in 23 years since it was approved in the United States, we know that the safety of mifepristone is that it's far safer than penicillin, Tylenol, even Viagra. The claims that somehow these petitioners, including a dentist, will somehow be overwhelmed with patients who have used mifepristone but who will seek their care is truly absurdist, because in 23 years that has not happened. That has not been the experience of the petitioners at all. And it is worth noting that this was a form of forum shopping, looking for a very specific judge who had already articulated anti-abortion views and placing a petition before that specific judge.
Thank you.
Thank you. Senator Grassley?
Dr. Goldenhorst, could you explain how women can still receive compassionate and necessary medical treatment from pregnancy complications without their provider performing an abortion?
Yes, sir. Thank you for the question. I think that, as I said earlier in my testimony, when women experience complications, and in my career I have had literally hundreds of women, both here and in other countries, have complications requiring delivery. When you are performing a procedure to save the life of the mother, it is not morally considered an abortion, and therefore it is ethically permissible. Compassionate care means that you consider the circumstances carefully, you act in the best interest of both patients. If the death of the unborn child is a result of your intervention, that is a tragic outcome, but nonetheless our priority is to save the life of the mother and preserve her functioning, and that can be accomplished without performing an abortion.
Dr. Scop, there's been discussion of long-term health impacts of complications from pregnancy. Data suggests that both chemical and surgical abortions can cause adverse and life-threatening health impacts. Can you briefly explain and discuss the possible complications and impact on health of women that can arise from abortions, including surgical abortions or the use of the abortion pill?
Yes, sir. Thank you for that question. So in my 30 years practicing caring for women, I've cared for many women who have been harmed by abortion. I've cared for a woman who died of a second trimester abortion from sepsis. I have, in my practice, another young girl died from sepsis after a first trimester surgical abortion in which her uterus had been perforated. I've cared for many, many women who have explained to me that their anxiety and depression is due to their unresolved guilt over an abortion. I trust those women to tell me what the cause of their concerns are. I've seen women who self-harm. I've seen women who turn to substance and alcohol use and abuse due to this guilt that they have. Regarding chemical abortion, and I would like to state that so that everyone is aware, the United States does not have any federal mandates to report any data about abortion. We do not know how many abortions occur. We do not know the complications, and we certainly don't know the deaths because, as I reported, it's well known that mental health deaths can follow abortion, and our CDC does not try to make that linkage at all. Countries that have made this linkage have documented far higher mental health deaths in the year following abortion compared to childbirth, including 6 times as many suicides. But regarding chemical abortion, the industry tells us it's safer than Tylenol. They're comparing Tylenol overdose deaths to the undercounted deaths from chemical abortion. There's no comparison. Women assume they mean normal Tylenol use. They don't realize that they're comparing it to deaths that happen from overdoses. The abortion industry tells us about the complications they know about, but my experience has been, because the women have been assured it is so safe, when they have a complication, they do not return to the abortion provider. They come to me as their gynecologist, or they come to the emergency room in distress. And so when we look at good quality records linkage studies that detect all chemical abortions and all subsequent events, we find 5 to 6% of these women present to an emergency room within a month. Approximately the same number will require surgery because their bodies cannot evacuate all of the dead tissue. And I am still caring for these complications in Texas, even though we've had abortion limitations for quite some time, because these drugs are circulating in the state to try to circumvent our state laws and provide abortions to these unfortunate women.
Dr. Wimmenhaus, in your opinion, how can we approach reducing mortality rates from pregnant women? And you might also touch on the fact that why is unrestricted abortion not a solution to this issue?
Thank you for the question. The solution to maternal mortality, and I've been working in this area globally and in the United States for many years, is to improve healthcare, health education, and to increase support to pregnant women. Abortion does nothing to address any of those issues. The main causes of maternal mortality have been for years, and in the most recent CDC data from 2021, are deaths from cardiovascular causes, infection, embolus, and so on and so forth. Abortion will not reduce those deaths. There is no argument and no paper anywhere that shows that abortion reduces maternal mortality. There are studies that purport to do so, but when you look at the essence of the studies, what they're saying is that, well, if you reduce the number of women at risk by performing abortions in them, that somehow reduces the number of mortalities. In point of fact, we cannot predict exactly who will have a poor outcome. We cannot predict who will have an adverse maternity outcome. And so that asks the question, what percent of high-risk pregnancies should we abort? 20%, 30%, 40%? I think the other issue really relates to community and civil society engagement in terms of helping women to have better outcomes for their pregnancies.
Thank you, Mr. Chairman.
Thanks, Mr. Chairman. Thank you all for being here today. And I want to begin by thanking Ms. Zyroski particularly for your courage in sharing your story today, but also Dr. Verma to you and all the OBGYNs, all the healthcare providers, the nurses, the escorts who are at clinics around the country providing protection and care in the face of the danger, real physical as well as emotional jeopardy inflicted on them. I think you are a profile in courage as well. In Connecticut, we now have laws, thanks to our state legislature, that help to protect women in other states, because we guarantee these rights in Connecticut, but in other states that come to Connecticut to exercise reproductive rights because of those dangers that you face every day in Georgia. When I first introduced the Women's Health Protection Act 10 years ago, the idea that Roe v. Wade would be overruled, in fact, was unthinkable because it was well-established precedent. It was long accepted under the principle of stare decisis. And 3 nominees came to this room to be confirmed before our committee and agreed that it was long established precedent, and under that doctrine of stare decisis, they could not see how it would be overruled. They didn't refer to that case. They made no promises, but they led us to believe that they believed that the integrity of Supreme Court precedent should be respected. I think the best way to refer to their testimony here, and I'm talking about Justices Gorsuch, Coney Barrett, and Kavanaugh, is that it was disingenuous. And I think a number of my colleagues would agree. Senator Whitehouse referred earlier to testimony from another justice who perhaps had in mind the same result despite Supreme Court precedent, that is Justice Scalia. And they're concluding, as they did in Dobbs, that Roe v. Wade was wrong with barely a few years after they established their respect for it, I think has helped to undermine the integrity and credibility of the court. I would like to ask you about not the legal issues here, Dr. Verma, but in hearing some of what has been said about the medicine, about the healthcare issues, whether you would like to correct some of what has been said here and just give you the opportunity to respond, because I trust women to make these decisions, not politicians or judges or senators. And I want to know what women should know from you in the face of what I think has been some disinformation here medically.
Absolutely, and thank you, Senator, for that opportunity. So I want to start by saying that the American College of OBGYNs, which represents over 60,000 OBGYNs across the country, along with over 75 other major science-based medical societies, have identified abortion care as incredibly safe, essential health care. This is not one profession. This is not one society. This includes the American Medical Association, the American Academy of Family Physicians, of Pediatrics, of Surgery, of Anesthesia. The science on this is settled. Abortion care is incredibly safe, essential health care. This is the consensus of the science-based, evidence-based medical community. In addition, the American Board of OBGYNs, which is the board that certifies all of us OBGYNs at this table, has identified abortion care as incredibly safe, essential health care with risk of serious major complications of less than 1%, and has actually said that misinformation about abortion. Spreading misinformation about abortion is medical unprofessionalism. In addition, we heard some people bring up Kermit Gosnell. What he did was terrible. To say that that represents the reality of abortion care in this country as a disservice to me, my colleagues, and my patients. I see my patients accessing abortion care from a place of compassion every day. Compassion for themselves, their existing families, their children. When we see a patient, we give them all of their options. That includes talking to them about adoption, continuing the pregnancy, and abortion, and confirm that they are completely sure before moving forward. And we provide them with abortion care in a safe, compassionate way. If someone chooses to continue a pregnancy, I'm also very happy to support them in that and deliver their baby. I do all of OBGYN. I think that focusing on people experiencing regret does a disservice to our patients who are making these informed decisions about their health care and lives and are experts on their own lives. We also have excellent data from the Turnaway study, which followed 1,000 women for over 5 years and showed that that the most common emotion after an abortion was relief.
Thank you very much.
Thank you.
Thank you, Mr. Chairman.
Thanks, Senator Blumenthal. Next is Senator Lee.
From time to time, the Supreme Court corrects prior errors. It happened with Plessy versus Ferguson, which was a bad decision. We've all acknowledged that, along with Dred Scott, along with Korematsu, are bad decisions. I like it when the Supreme Court is able to correct prior errors. That is what occurred with Dobbs. Dobbs corrected a prior error. It's difficult to endure hearing people say that they're worried about the credibility of the court, when sometimes those words are uttered by people who are themselves actively, willfully, deliberately attacking the credibility of the court, sometimes as officers of the court. We're seeing this through unfair attacks on Justice Thomas and other members of the U.S. Supreme Court, and it's got to stop. Look, Dobbs was right. As a matter of constitutional law, this is a matter not for the courts to decide, but for elected lawmakers, typically in state legislatures, not our national legislature. So if you don't like the policy outcome, go to your state legislature. But this is not an issue in which the federal judiciary is somehow empowered. There is no reproductive rights clause of the U.S. Constitution. So let's not pretend that we're worried about the credibility of the court if we are simultaneously attacking the credibility of the court and its ability to do its job. Now, a lot of these issues relate to this legislation that's been introduced in the wake of the Dobbs decision, which is itself way more radical even than Roe versus Wade was, and way more radical than where Americans are comfortable going. You know, 69% of Americans are uncomfortable with abortion after the first trimester, 69%. But you'd never guess that from the way Democrats in the United States Senate vote on these issues, where essentially all of them support or appear to be comfortable with second and third trimester abortions. And in fact, all but I think 2 members of the Democratic caucus in the United States Senate voted against the Born Alive Abortion Survivors Act. And so this legislation Democrats are now pushing would prohibit any state law from regulating abortion within a state's borders, essentially ever, not to protect girls, not to protect women, not to protect health, safety, and welfare, not to protect the rights of a baby born alive. Now, putting aside for a moment the life of the child, when considering the health impact of abortion on women, I think there are important considerations to make. Dr. Ingrid, Dr. Scop, I'd like to start with you. What concerns do you have for the physical and mental well-being of women who have late-term abortions?
It's well established that women who have late-term abortions are at much higher risk for mental health complications, as we mentioned, anxiety, depression, substance use and abuse, and suicidal ideation and self-harm.
Let's talk about suicide for a minute. Those who have second or third trimester abortions, late-term abortions, do they have, what do their higher suicides look like?
In the United States, we do not have data on this because, as I mentioned, backing up to maternal mortality, this is data is collected until a full year after the end of the pregnancy, and it is virtually impossible because the CDC mostly looks at death certificates. It's virtually impossible to link say a coerced abortion and a suicide 6 months later.
Right.
And I don't think that there are many efforts to do this.
By the way, how many abortions are medically indicated, medically necessary?
Using the definition that the intent is to kill the baby, I would say none. As we discussed earlier, occasionally there is the need to do a separation of the mother and the baby. The intent in that case is to save the mother, and sometimes the baby regrettably dies. But even if you use that or if you said that, well, that counts as an abortion, it's still far less than 1% of the abortions in our country.
Very good to know. Now, as you have noted, women are 4 times more likely to experience serious medical complications from a chemical abortion as a surgical abortion. Why is the abortion industry pushing chemical abortion? Does it have more to do with the fact that this is an industry that makes a lot of money off of that? Or does it have more to do with the fact that that dispenses with a lot of inconvenient things, like the fact that we've got Planned Parenthood clinics that have been caught on tape telling girls not to tell the age of the person having the abortion, because then they would have a duty to report it. What is that? What's causing that?
I think there are definitely advantages for the abortion industry to promote chemical abortions. They don't have to hire a surgeon, pay for sterilization of instruments and the costs that go along with that. And the reality I would like to acknowledge is that, again, about 90% of obstetricians do not perform abortions, and even obstetricians who claim to be pro-choice, many of them will not perform surgical abortions. So I think there was a staffing issue that began the promotion toward chemical abortion. There may be some advantages in terms of funding, but now that we see—
Is there a profit motive, perhaps? Could that—
There was a time that the cost of a surgical abortion and a chemical abortion were approximately the same, an average of about $575. But I think we also see, in light of states beginning to have pro-life restrictions, that this is a way to get around those restrictions and provide abortions in states that are trying to protect unborn life.
Thank you. Thank you, Mr. Chairman. I see my time has expired.
Senator Hirono.
Thank you, Mr. Chairman. Dr. Scop says that Ms. Zyroski's doctors misinterpreted Texas law, which criminalizes abortion. So her doctors were acting under advice of the hospital's ethics committee, which includes lawyers. So to suggest that doctors should ignore the advice and the cautions of their own ethics committee is not realistic. So, Professor Goodwin and Dr. Verma, wouldn't you agree that the Dobbs decision led to this kind of chaos as to appropriate care to be provided in
That's
these
absolutely
situations?
right, Senator. The Dobbs decision did unleash a torrent of uncertainty throughout the United States, where doctors fear losing their medical license to practice if they intervene before the law says that they should, these laws. They also fear criminal punishment and civil fines. As I mentioned, in the state of Texas, there can be criminal punishments up to 99 years incarceration, fines up to $100,000. These are some of the considerations that doctors struggle with, including then losing their medical license to practice.
Absolutely. Every individual person, pregnancy, and family is different. And the reason we train for so long as doctors is to be able to look at the unique person and medical situation in front of us and make decisions with them about the best course of action. When we have to think about what the law says and if a patient is sick enough for us to be able to legally provide them care without risking criminal prosecution or losing our livelihood, that delays care. It prevents people from getting the care that they need.
I think to expect that doctors and hospital personnel will risk losing their license or being held criminally liable, that is something that is a risk that I would say a lot of doctors and others wouldn't want to take. Professor Goodwin, we've heard today that women are coerced to have abortions. Is that the data, that women are coerced, not that women freely choose to have abortions. Can you enlighten us?
Sure. Thank you so much for that question. The coercion is the coercion to be pregnant, to remain pregnant, states enacting coercive laws that force women, girls to endure pregnancies that they do not want, pregnancies that may be the result of rape and incest, pregnancies that may threaten their health. This is what is actually taking shape by these laws, and it's worth noting the historical arc of this. We cannot forget that forced pregnancy was also a feature of American slavery, and we must remember that the effort to ratify the 13th Amendment, which abolished slavery and involuntary servitude, specifically related to the forced pregnancies that were placed upon Black women and girls that they had to endure. These forced pregnancies were so normalized that advertisements in the 1700s and the 1800s tell us quite clearly what it was that they endured. And if you will, let me just read a couple of them to you, just so that we know exactly what the senators were trying to get rid of in American slavery. They included advertisements such as the following: runaways. The following Negroes ran away or absconded from me on Friday last. A Negro woman named Lena, about 18 years of age, and her child named Mary, about 2 years old. Mary is a bright mulatto child. That from the Republican Star, 1811, Easton, Maryland. $5 reward, ran away on Tuesday the 13th. The subscriber's Negro girl named Maria with her female mulatto child, about 9 months old. Maria was lately the property of Dr. Thomas McCall. March 22nd, 1810, Charleston, South Carolina. For sale or exchange, a young, healthy Negro wench and child. 'Tis not convenient to have a breeding wench in the family. Virginia Chronicle, March 9th, 1793. These kinds of advertisements were what senators read as they drank their morning coffee and orange juice. So deeply troubling that baked into the story of American slavery and abolition is the story of sexual terrorism inflicted on Black girls and women, so troublingly normalized that the descriptors breeding wench and mulatto child simultaneously read as mundane daily affairs and horrors.
Thank you very much, Professor, for reminding us there was a time when women did not own their own bodies. And that is exactly where we are today, as far as I'm concerned, that women in this country, persons, are not able to make free choices about their bodies, and what to be forced to have a child is probably the most freedom-taking thing that we can impose upon anyone in this country. And thank you for that reminder. Professor, you also mentioned about judge shopping or foreign shopping. I think this is an issue that we need to face in this country also. It was very clear that in Texas, which has 27 divisions, 20 of which has only one judge, it was so clear that there was judge shopping going on with that judge. And would you say that we should do something to prevent judge shopping in this country?
The forum shopping that took place was quite clear in this case, as Judge Kacsmaryk had, in fact, expressed anti-abortion views and activism. And most recently, it's been disclosed that he removed his name from a law review article that was going to be published at the University of Texas that also further explained his anti-abortion views, and that name was removed before he came before the chambers for confirmation. So something does need to be done.
I take you.
Thank you,
Thank you for
Senator
that. Thank you.
Thank you very much. Senator Cruz.
Thank you, Mr. Chairman. There's probably no issue in modern American politics that engenders sharper disagreement than the question of abortion. I think everyone here agrees on that. It's a deeply moral issue that reflects our values, who we are as a country. It's an emotional issue. It's a personal issue on which people feel very strongly. I believe the American people should decide abortion policy. I believe that's what our Constitution designs. Unfortunately, my Democrat colleagues on this committee disagree. They do not believe in democracy when it comes to the issue of abortion. They want unelected judges to set one standard for the entire country. And if the voters disagree, the voters have no choice. And look, the reason the Democrats want this issue to be out of the hands of the voters is quite obvious. Because the modern Democrat Party is wildly out of step with the American people on the question of abortion. The current position of virtually every Democrat senator in this body is that abortion should be absolutely unlimited, available up until the moment of birth, and even, shockingly, in some instances, after birth. That partial birth abortion should be fully legal. That there should be no parental notification and no parental consent, no matter how young the girl is who may be seeking an abortion. And that all of it should be funded by taxpayer money. Now, that is an extreme and radical view. How extreme and radical? Well, according to a Harvard-Harris poll from last year, 10% of Americans, only 10%, support abortion on demand up until the point of birth. That's the position. If you want to be a Democrat in the Senate, that's the position you have to embrace, because that's where the money is. That's where the activists are. That's where the angry voices are that fuel a Democrat campaign. But 90% of Americans look at that position and say, we disagree. And so you understand now why my Democrat colleagues don't want this decision decided by the voters. Because if 90% of the voters disagree with the extreme policy decision they've embraced, their position will not prevail at the ballot box. And by the way, it's not just the voters in the United States who disagree with Senate Democrats on this. It is virtually every voter on planet Earth. The United States is such an extreme outlier. Out of the entire country, there are only 7 countries on Earth out of the entire planet that allow abortion after 20 weeks. And yet every one of my Democrat colleagues wants to do so. Europe, virtually all of Europe, including the left-wing socialists, the Greens there, they think the Democrats in this body are loons on this issue. Sweden has an 18-week limit on seeking an abortion. None of my Democrat colleagues would vote for Sweden's law. France has a 14-week limit. France! None of my colleagues would vote for France's law. Germany and Luxembourg have 12-week limits. And the position of Democrats is 40 weeks, up until the very moment of birth, no limits at all. That's a horrifying position. I suppose my Democrat colleagues can comfort themselves with the company they're in. Communist China, Iran, and North Korea, and the National Democrat Party. They all have the same view. Those tyrannies, at least, are explicit, which is life has no value. And so they don't embrace any limits. And by the way, look, there's so much rhetoric on this issue that a skeptical listener would be justified doubting what any of us are saying. But if you don't believe what I'm saying, look to the votes. In the wake of the Supreme Court overturning Roe and sending this decision back to the voters so the voters could decide, what did my colleagues in the Senate do? Promptly voted on a bill that would strike down just about every reasonable restriction in the country that the voters have decided to legalize partial birth abortion, provide no protection for unborn children. Those are extreme positions. And Dr. Scop, I'd like to ask you, what are the consequences of unlimited abortion on demand? What does a 40-week or a 36-week unborn child who is enduring a partial birth abortion, what does that child experience if that procedure is allowed to happen?
a partial birth abortion delivers the baby intact. So the very first thing that would happen is that the woman's cervix must be aggressively dilated to a large dilation. That is very likely to damage her cervix, and several high-quality systematic reviews have documented increased risk of preterm birth in a subsequent pregnancy after a procedure like that. So not only is it hurting her this time, it will lead to further complications such as cervical incompetence. The baby generally is not killed first. As I reported, 70% of late-term abortion providers say they do not routinely do this. These babies are highly likely to continue to live throughout the process of labor. They're delivered as a breech, and their head is crushed. So that would be the point when they would die, is when their head is crushed. Other late-term abortion, I mean, they're blind procedures in many cases. So the instruments could damage the uterus. They could puncture the uterus. There are a number of horrible consequences documented where adjacent bowel has been disrupted, urinary tract injuries, hemorrhage. There is really no reason that an abortion needs to be done that late, ever.
Thank you.
Senator Booker.
Thank you, Mr. Chairman. I want to thank all the witnesses for being here today. Ms. Goodwin, I'm appreciative of your scholarship, and I want to ask you to maybe go a little bit deeper with me when it comes to protecting women. The testimony by Ms. Zyroski and Dr. Verma were really compelling to me, but the data is really stunning. U.S. women are more likely to die during or after pregnancy than anywhere else in the world. In the developed world, excuse me, and public health experts are predicting that this will get a lot worse. Right now, the United States is only one of 13 countries in the entire planet where maternal mortality rates, deaths of women from pregnancy until 1 year postpartum, is worse today than it was 25 years ago. We know that a 2022 University of Colorado study projected that in the first year following a nationwide abortion ban, the number of maternal deaths would increase 13%, and in subsequent years, maternal deaths could increase 24%. And a Commonwealth Fund found that states with heavily restrictive abortion access in 2020 had maternal mortality deaths that were 62% higher than they were in states where abortion access was easily more accessible. I mean, these are stunning numbers when we're talking about the health and well-being of women in this country. But you went one step further, and I'd like for maybe this to be the second layer of your response about the stunning realities for Black women.
That's right. And thank you so much, Senator Booker, for your question and also your commitment on these issues. For Black women, it's devastating. Nationally, 3.5 times more likely than their white counterparts to die during or shortly after pregnancy, but that's nationally. When we go to certain counties and cities, then it can be 5 times, 10 times, 15 times more likely their deaths than their white counterparts. I'd also like to correct the record here because there's been much said about the history of eugenics being one that was portrayed on Black women. To clarify, in 1927, the case Buck v. Bell, which is a horrific case that introduced eugenics into the United States, was a case that explicitly involved a poor white woman. And this is important because it's a commentary that Justice Thomas has made, and we've heard today that early eugenics was about Black women. It was a horrific campaign that was targeted at poor white people like Carrie Buck in the state of Virginia. And it was a law then, the eugenics laws that spread throughout the United States. But that history is important because of inaccurate conflations. It is true that later on during Jim Crow, when Black women demanded more, such as voting rights, such as equality, that the Mississippi appendectomy, which was coercive sterilization, was introduced. And it's worth threading the needle because the person who helped us learn about that was Fannie Lou Hamer, as she threaded together the lack of bodily autonomy, the lack of voting rights, and especially as there are those that say, take this to the democratic process. What does that mean in states where Black people have historically been disenfranchised from voting, including Mississippi, Georgia, and other states with abortion bans?
Thank you. Dr. Verma, I've been working on maternal mortality issues since I came to the Senate. And since I discovered how stunning the numbers are in our nation relative to other countries, how many women are dying in childbirth, and the fact that Black women are 3.5 times more likely is stunning. And I'm wondering, the data that I'm looking at from, nonpartisan, I should say, independent science-based research really are predicting that these rates that are already horrific in our country are going to rise. And we heard the testimony of Ms. Zyroski. Could you just give us, from your professional standpoint, an understanding that, again, this hearing, often they're set out to be about something and then they get spun off, but this hearing really is about the consequences for the health and well-being after the Dobbs decision. These staggering numbers, some of which I read, what is your experience and how do you see the next months, if not years ahead?
Yeah, absolutely. Thank you for that question. So we've seen in the data that there is a link between places with abortion restrictions, stricter abortion restrictions, and higher rates of maternal mortality in the United States. Georgia has one of the highest maternal mortality rates in the country and has very strict restrictions on abortion. And we've seen, based on data out of places like Texas, that even when these laws have exceptions for things like medical emergency, we've heard about the confusion on the ground, and we've seen in the data that people with high-risk pregnancies still have a harder time getting the care that they need and often are denied that care. And so we absolutely expect to see more people getting hurt because of these laws. I also want to just correct, so abortion care, again, is incredibly safe. We've heard a couple mentions of it being a blind procedure. As the one OBGYN on this panel that does do full spectrum reproductive health care, including abortion care, we do this procedure incredibly safely with ultrasound guidance. I also want to address that, again, what Chairman Durbin said earlier, that in this country, 90% of abortions occur in the first trimester, less than 1% occur after 20 weeks, and when abortions do occur later in pregnancy, it is usually because something has gone terribly wrong with the patient or the pregnancy. Abortions up until the moment of birth simply do not happen. That does not reflect the reality of abortion care in this country. In addition, what the Democrats are trying to do here is to allow people to make these important decisions without legislative interference. I perform abortions for grandmothers, for adolescents, for doctors, for people of faith, for people who never thought that they would need an abortion. What each of my patients needs the ability to do is to make these important decisions themselves about their health care and their lives.
Thank you, Dr. Berman. Thank you, Mr. Chairman.
Thank you, Senator Booker. Senator Tillis?
Thank you, Mr. Chair. Thanks to all the witnesses for being here today. Special thanks to Dr. Rubenhorst from my home state for being here. Dr. Rubenhorst, just one point. I've had somebody ask me what legislative measure I was most proud of when I was Speaker of the House, and I told them that it was compensation for eugenics victims in North Carolina, first state to ever do it. And Professor Goodwin, I would say I studied the issue a lot to get support. And it's very clear it was disproportionately racially motivated, beginning with the late 50s on into the early 70s, when I've met a victim of the Mississippi appendectomy who's about my age, who found out when she was trying to have a child that she had been sterilized. Dr. Rubenhorst, I've noticed you I was here for all the testimony. I noticed you take a lot of notes. So the first question I have, I hate to put you on the spot, are there any points that have been made here that in the questions asked at this point to this stage that you would like to either clarify or take a counter position from some of the other witnesses' testimony?
Sure. Thank you very much for the chance to do that. I think that a couple times people have mentioned the issue of maternal mortality being higher in states with restrictive abortion laws. I'm very familiar with that literature. There are about 7 papers. Every single one of those studies has a methodological flaw. The most important flaw is that none of those studies take into account issues like health workforce, like the distribution of health workers, the lack of care in rural areas, and economics. So I feel that literature is very flawed. It is not by any means definitive and cannot be stated to demonstrate that abortion restrictions lead to increased maternal mortality. On the contrary, there's a study that was done in Mexico indicating that looking at all of these factors and showing that the most powerful influence on maternal mortality was the availability of skilled help at birth and the environmental situation. For example, did the household have running water and sewage and so on and so forth?
I see some of your colleagues taking notes, so I'll invite a member on the other side of the aisle to ask them if they want to yield time for rebuttal. But I do think if we're going to be instructed, if we're going to make good policy here, we have to be fully informed. That's right. And I believe that the factors that are leading to those mortality rates are not as simple as either extreme of the arguments presenting here. So that's not putting us in a good position to come up with reasonable policy. Doctor, I'm going to call you Ingrid before I ask this question. I've heard you referred to as Scop and Scope. Which do you prefer?
It's Scop, but Ingrid is fine.
Okay. Dr. Scop, you were, and Mr. Chair, I'd like to seek consent to put an article from Detroit Catholic where Dr. Scop is quoted into the record.
Without objection.
I've got the specific section of the Texas law. I'm not an attorney. That my attorney suggests that Ms. Zyroski's, did I pronounce that right, ma'am? Situation that perhaps the doctor was given bad legal advice. It appears in a section under section 178.002 that they could have had, knowing that the condition that Ms. Zyroski had was an inviable fetus and going to threaten the health of the mother, and within a few days she did experience sepsis. It seems like to me maybe the doctor wasn't guilty of malpractice, but a legal advisor was guilty of malpractice. Would you agree with that?
I think what's going on the ground in Texas, and I will agree with Dr. Verma and Ms. Zyroski, there is confusion. Yep. Normally, doctors, of course, are not legally trained, and normally they depend on advice from their professional societies to help them understand new laws. What has been noticeably absent in Texas is any statement from the Texas Medical Association, any statement from the Texas Board of Medicine, Board of Pharmacy, Board of Nursing, Hospital Association. So all of these organizations, you can figure out why they might be silent, make your own conclusions, but they have been silent, yeah. And that is the reason for the confusion.
In my read of it, I honestly... Ms. Zyroski, I'm blessed with a granddaughter named Willow, 2.5 years old. If my daughter, and I'm not even going to talk about it because I don't think I can get through it, but this is a legal professional who's guilty of malpractice, and the legal advisors of the medical centers in the state of Texas should be honest, set their political agendas aside, and give good legal advice so doctors can provide care that I think, in Ms. Zyroski's case, she was entitled to, and instead they let her get very sick. Thank you, Mr. Chair.
Senator Tillis, I'm going to give Ms. Zyroski an opportunity to respond. Although she was in extreme situation in the ICU when this happened, I know that her husband is with her today, and I'm sure they both discussed some of the issues that have been raised about your care, whether there was medical malpractice or legal negligence of some sort. I want to give you a chance to respond if you can.
Thank you for the opportunity. So I'm not a legal expert. I'm not a doctor. I think that my doctors and my healthcare team were doing the best that they could with the information that they had and the guidance that they were being given by the ethics board at the hospital. I know that they also consulted with colleagues at the hospital that I was at, as well as outside of that hospital in Texas, and they asked several times to several physicians at several facilities whether I could be transferred, if there was different health care that could be provided somewhere else, if I could have received an abortion somewhere else. And across the board, no matter who they asked, they were told time and time again that no, they wouldn't have been able to provide an abortion. So it wasn't just my healthcare team, it was everyone else that they consulted during the whole 3-day ordeal as well as afterwards.
Yeah, Mr. Chair, just to be clear on my position, I believe that I don't believe doctors should be lawyers unless they've got a legal degree, and I don't think lawyers should be doctors unless they have a medical degree. My point was not about the doctor. They were in a difficult situation. They were trying to care for you. My question is what the motivation was to not read the plain text of the statute that a non-attorney can read and understand that that should have been a legal basis for saying that they could have proceeded with a procedure that resulted in devastating consequences for a prospective family. Thank you, Mr. Chair.
Well, I'm going to conclude, if I might, as chair, and just say the reason we are at this moment in history is because the Dobbs decision decided we were going to redefine state by state the access to abortion and define the legal and medical circumstances. This is tricky territory. It's dangerous territory, as we've been told here, and that's why I think we've had this hearing this morning. Senator Padilla.
Thank you, Mr. Chair. I want to start just by thanking you for holding this important hearing and thanking all the witnesses for joining us today. As we discuss the efforts we've undertaken to ensure a woman's right to abortion care, it's not lost on me that this fight is actually larger than abortion care alone. As we work to address the unprecedented actions taken by the far-right wing of the Supreme Court, it's not lost on us that as they're working to strip away basic rights, they're also failing to hold themselves accountable for some common sense ethical standards. So there's a lot going on here. I look forward to working with the chair to explore those greater issues as well, to make sure that we can restore some public confidence into a co-equal, they claim to be completely independent, but is a co-equal branch of government as we work to protect the rights and protections that so many Americans hold dear. Now, my first question deals with sort of the separation of powers and role of the courts question. You know, it's clear that one troubling aspect of the recent Fifth Circuit decision, which many scholars and even fellow judges found legally unsound, was its attempt to intrude on a decades-old public safety-driven decision by the FDA. Now, the FDA, we all know who the FDA is and what the FDA does, but the FDA is the agency that Congress has entrusted with making scientific decisions relating to our health and safety. So when the FDA tests and approves a medication for use, people rely on that. They have trust in the testing and approval process. And so when activist judges take it upon themselves to overstep the separation of powers and intrude on the FDA's decision-making authority, the authority entrusted in it by Congress, it leaves science no longer to just the scientists. And Senator Tillis is talking about, I don't want doctors to practice law unless they have a law degree. He doesn't want lawyers to practice medicine unless they have the medical degree. I don't want justices making scientific decisions unless they have that education expertise. Dr. Verma, simple yes or no question. Is regulated medical abortion in the United States safe?
Yes, absolutely.
So can you describe then the risks to patients when judges rather than scientists are making decisions about medicines that Americans rely on?
Absolutely. Thank you for that question. So we know based on decades of data that medication abortion is incredibly safe and effective. By regulating a medication or taking a medication off the market that we know is safe and effective, we limit patients' ability to get the care that they need. That includes care for people that need abortions and for miscarriage management. Mifepristone is used very safely and effectively for management of miscarriages and shortens the amount of time it takes someone to pass a pregnancy. A lot of people experiencing miscarriages are already going through a traumatic event, and so to be able to offer them the most effective treatment option is incredibly important.
Okay. Thank you. Now, despite the lack of attention that it gets in the press coverage, We know that abortions are sometimes necessary to stabilize a woman's condition, right? When a woman's health or life is in danger, that becomes part of the conversation. It should be more of the conversation than it is in our national discourse. Yet it seems like so many states, post-Dobbs, are passing laws that are creating, either unintentionally or sometimes very intentionally, conflicting laws leading to confusion and impossible decisions to make on a moment's notice. And Exhibit A is your testimony, Ms. Zyroski. So first of all, let me thank you for being here. Thank you for your courage and your bravery to share your experience. Some people in the legal world say, well, there's a conflict between state and federal law. Well, there's a process for hashing that out through the courts. That takes a long time. In the meantime, we have women showing up in hospitals and emergency rooms that can't afford to wait. And you described your experience from the medical perspective. Just wondering if you could take a minute to share what kind of mental anguish that experience was like in while you were in the ICU and since then. And if you have a specific message for women living in states that are denied abortion care or access to the care that they need, but live in a state that's clamping down on access and options for them.
Absolutely, and thank you for the opportunity. We've heard a lot today about the mental trauma and the negative, harmful effects on a person's psychological well-being after they have an abortion, supposedly. And I'm curious why that's not relevant for me as well, because I wasn't permitted to have an abortion, and the trauma and the PTSD and the depression that I have dealt with in the 8 months since this happened to me is paralyzing. On top of that, I'm still struggling to have children. And I wanted to address my senators, Cruz and Cornyn, who neither of whom regrettably are in the room right now. But I would like for them to know that what happened to me, I think most people in this room would agree, was horrific. But it's a direct result of the policies that they support. I nearly died on their watch. And furthermore, as a result of what happened to me, I may have been robbed of the opportunity to have children in the future. And it's because of the policies that they support. What happened to me was horrible, but I am one of many. And quite frankly, I'm lucky. I'm lucky that I have a husband that could take me to the hospital. I don't have other children that I had to worry about finding health care for. I have a job that was understanding, that allowed me to grieve for 3 days as I waited to almost die. What about all of the women that don't have those same opportunities, that don't have access to health care, that don't have health insurance, that don't have a partner? What about them?
Thank you.
Senator Kennedy.
Thank you, Mr. Chairman. Thank you all for being here today. Professor Goodwin, help me understand your point of view. I think this is a yes or no question. Do you support it being legal to abort an unborn child up to the moment of birth?
Senator Kennedy, it is not a yes or no question. I support women like Ms. Zyroski. Women across this...
No, ma'am, I don't... I think it is a yes or no question.
No, well, let me answer.
If there were a law that's, I'm just trying to understand your perspective, and I'm not accusing you of this.
Of course
not. But you know, people sort of talk around this issue. If there were a bill that said that a woman has an unfettered right to abort an unborn baby for any reason up to the moment of birth, would you vote yes or would you vote no?
Senator Kennedy, I refuse to be shackled by your question. What I have answered is that there are conditions that occur
you don't know
during
whether
pregnancy.
you would vote yes or no?
There are conditions during pregnancy that mean after 10 weeks,
No,
14 weeks,
I said
20
unfettered
weeks,
discretion.
24 weeks,
You would
conditions
support.
such as Ms. Zyroski.
You're here
and
advocating.
I would support her life.
I
would
understand,
support her
too,
personhood.
But you're advocating a law.
I support her personhood.
You're advocating a law that says that an unborn baby can be aborted up to the moment of birth for any reason, are you not?
Let me clarify what the 14th Amendment says in the first sentence, that citizens of this United States are individuals that are born. That is what our Constitution says.
But
Do
why
you
won't you
support our
answer my
Constitution?
question, Professor? I'm not trying to argue. I just want to understand what your position is, and I think you're afraid to say that you do support that. If you do support it, I think you, just for the purpose of a intellectual discussion, you ought to just say so.
For purposes of an intellectual discussion, I'm happy to have that with you. But
Well,
that's
then,
not the tone of...
could you answer my question? Do you support, please? I mean, you teach. Okay, I'm sure you've had students ask this question. Do you support making it legal to abort an unborn baby for any reason, up to the moment before birth?
Senator, let's have that intellectual discussion that you want.
We could start if you'd answer my question. I can't go to my next question until you answer that question.
I want you to be able to go to your second
good.
and your third
Answer it for
questions.
me.
I do. But as I have explained, there are many different conditions.
No, I said
during
unfettered
a
discretion. No conditions. I'm
No.
making it easy for you.
Well, I've already shared with you, Senator, that I
get
support
it.
women's
I don't want to use
person-
all my time. You're not going to
And I
answer
support
it,
Ms.
and that is your
Zyroski's
right. But I
personhood.
would respect you more if you just say, "Here's
I'm
my
sorry
answer."
that you don't respect
I
me
do
very
respect
much.
you, but I said I'd respect you more if you just answer my question. Doctor, tell me how to say your last name. Ms. Dr. Rubenhorst, do you support a law that would allow, for any reason, unfettered discretion, the abortion of an unborn child up until the moment of birth?
No.
You don't. Dr. Verma?
Senator Kennedy, so I'm the one doctor in this room that does provide abortion care, and I can tell you that does not reflect the reality of abortion care.
I understand. I'm just asking a question.
It simply doesn't
But do you support it? There are bills before Congress that will allow that to happen. You don't support it, or are you going to not answer my question?
As the doctor in this room who does provide abortion care, that is not how abortion care in this country works. It's a hypothetical that does a disservice
But if a
to our
patient came to you and said, I'm going to probably have a baby this week and I've changed my mind, and I would like you, doctor, to abort the child, would you do it?
that is not how abortion care in this country
But if
works.
a patient did, would you do it?
My job as the doctor is to look at each individual situation.
I mean,
but
I'm
have
sorry, I don't
never-
mean to be rude, but I can tell neither you nor the professor will answer my question.
I
And I
have
think
nev-
you both have an opinion, and I don't understand why you won't share it. We're going to solve this problem.
I've
Doctor-
provided care for a
Doctor,
few
how
years,
about
and I've
you?
never
Could you-
seen that situation.
How about you, Doc? Would you?
Do not support unfettered abortion. And I would like to point out that if a woman did have a life-threatening condition in pregnancy past approximately 22 weeks, that baby can be delivered alive by induction or C-section, and we can try to save that baby. The intent of abortion is a dead baby, and that is not necessary in that situation.
I mean, I want you to all understand where I'm coming from. This is a tough issue. And it's a tough issue because there's some tough questions we've got to answer. And when you won't answer the questions, when you're invited by my Democratic friends, the majority, and you won't answer the most fundamental question, we've got a bill in front of us that will basically say a woman has the unfettered right to abort at any time for any reason up to the moment of birth. And that's a gut check issue. And I would expect you as experts to answer that truthfully, how you do it. Thank you for your indulgence, Mr. Chairman.
Senator Ossoff?
Thank you, Mr. Chairman, and thank you to all of the witnesses for joining us and sharing your experiences and perspective. It's been tremendously impactful to hear from you. And Mr. Chairman, I do want to note and acknowledge that we have a Georgia physician with us, and Dr. Verma. Thank you for your work providing health care for Georgia women at a time when the provision of health care for Georgia women is under attack by elected officials in Georgia. As you noted in your opening remarks, where one of the most extreme laws in the country has been enacted, a 6-week ban on abortion, which takes effect before many women even know that they are pregnant. In the midst of a maternal health crisis in our state. Mr. Chairman, I don't know if you've heard these statistics, but more than half of Georgia counties have no OBGYN at all. No OBGYN in more than half of the counties in our state. We have one of the worst maternal mortality rates in the United States. Even worse, much worse for black women in Georgia. And a shortage of qualified providers of OBGYN care. And so, Dr. Verma, what I want to discuss with you as we consider the impact on human health of Georgia's extreme 6-week abortion ban is how this risks worsening our shortage of qualified physicians. I'm looking at data here from the Association of American Medical Colleges that new OBGYNs are much less likely to apply into residency programs with extreme abortion bans like the 6-week ban in Georgia. And I think we all recognize this, but Dr. Berman, these physicians provide the full spectrum of perinatal care. So what does the state's OBGYN shortage mean for Georgia women, please, Dr. Verma, based upon your professional experience?
Thank you, Senator Ossoff, and thank you for everything that you do for healthcare providers and patients in Georgia. So I am very concerned that the law in Georgia, our 6-week ban, is going to make the healthcare shortage worse and affect providers wanting to go into OBGYN and provide in Georgia. I have talked to multiple medical students and residents who say they aren't going to stay in Georgia because they don't want to be in an environment where they can't practice evidence-based medicine and have to worry about whether they are going to be criminally prosecuted, have their license removed, have their livelihood threatened. The same procedures that we use for abortion care are also used for miscarriage management. The same medications, the same procedures. And so I've talked to trainees who worry that if they stay in Georgia, they won't get the training that they need to take care of someone who comes in at 14 weeks bleeding heavily, that they won't be able to provide them with the emergency care that they need. We know based on survey data that 90% of OBGYNs have said that they've had a patient in the last year that needed abortion care, and the vast majority have gotten that patient connected with the care that they need, even if they personally feel conflicted with abortion, even if they don't provide the care themselves. So this is something that OBGYNs support. They want patients to get the care that they need, and they're worried that they won't be able to practice evidence-based medicine in Georgia and are leaving.
So, and just to be clear, because I think it's vitally important that Georgians understand this and that the Senate understand this. The 6-week abortion ban in Georgia, backed by threats of criminal prosecution and imprisonment for physicians. And we see in the data that these laws are deterring OBGYNs from pursuing residencies in states with laws like this.
Absolutely, and you're absolutely right that then affects not just, again, like I'm an OBGYN that does abortion care, but I also deliver babies. I do GYN surgery, I do cancer screenings, I do full spectrum OBGYN, as many OBGYNs do. So this is not just going to affect access to abortion care, it's going to affect access to all care, all reproductive health care in our state. I practice in Atlanta, where we've already experienced the closure of a major medical system that's having devastating effects on access to care in our city. You're absolutely right that half of counties in Georgia have no OBGYN. I expect this is just going to get worse.
Thank you, Dr. Verma. Thank you, Mr. Chairman.
Senator Blackburn.
Thank you, Mr. Chairman. Dr. Verma, I want to ask you very quickly. You talk about evidence-based medicine. Do you consider a heartbeat evidence-based? Would you consider that a living? Would you consider that a living being if there's a heartbeat detected? Would that be evidence enough that there is life?
So based on evidence-based medicine, and I think what you're trying to get at is that...
No, I know what I'm trying to get at.
Could you clarify for me what you're trying to get at?
No, let me just say, you talk about evidence-based medicine. A beating heart is a sign of life. And Dr. Scop, earlier you said a heartbeat can be detected at 28 days. Am I accurate? Did I understand that? I was watching in my office.
Fertilization, usually it's about a week later before we can detect it via ultrasound technology.
Okay, so at 23 days. Thank you I think that's the evidence of life. I want to talk for just a moment. Dr. Goldenhorst and Dr. Scop, late-term abortions. When I'm talking to women in Tennessee, what I find is most people, regardless of party affiliation, they are opposed to late-term abortions. And from the work that I've done in the House and in the Senate, what I have found is that there seems to be dismemberment of the baby involved in these late-term abortions. And many times there is an injection to stop that heart from beating. Is that accurate? Am I correct on? Okay, you all are nodding yes. Okay, and then there are occasions during late-term abortions when the baby survives that process, and then the baby is delivered alive. And I've talked to so many women who were so highly offended with Governor Northrup of Virginia's remarks around that. I'm just going to read these for the committee so that it's accurate. He said, if a mother is in labor, I can tell you exactly what would happen. And of course, he's referring to a mother in for an abortion, and she has gone into labor. He continues, the infant would be delivered. The infant would be kept comfortable. The infant would be resuscitated if that's what the mother and the family desired, and then a discussion would ensue between the physicians and the mother. So, Dr. Goldenhorst, you have delivered a lot of babies. Okay. As someone who has done this and who has personally cared for women who suffered physically and emotionally from the complications of abortion, then tell me is there any way, any reason anyone would think that statement from Governor Northrup was a compassionate, caring statement?
Yeah, I think it's very clear that it's not a compassionate statement, because if you allow a child, and in fact, I think the legal framework in this country is that if a child is neglected and allowed to die or killed, that's infanticide, and that's something that could be prosecuted. I think that it's the same situation if a woman undergoes a late abortion. We know that past 22, 23 weeks, we are able to resuscitate those children and they'll live. So I think that it is morally inconsistent to, and this has happened in hospitals where I've worked. In one room, you're fighting for the life of a child who's 22, 23, 24 weeks, and in another room, you're aborting a child that's 28, 32 weeks.
Yeah, and visiting our NICUs and having friends and family that have had babies in the NICU, and you pray over these babies for the continuation of their life and their health and their recovery. And then when you hear about the practice of late-term abortion, it's just hard to square that up. I find it very difficult. Dr. Scop, I want to talk to you for just a minute. And I had talked with the DOJ about the attacks on pregnancy centers, which there has not been a push forward to address these. But there have been many cases, and we've had some in Tennessee, where they've gone after people that were across the street from the center on and were going through protesting. And I see my time has run out, but I do want to get this question in, and you can answer it for me. We'll do this, Mr. Chairman. I'll take it from her in writing. I would like to know if you think DOJ and the Biden administration is doing enough to protect the pregnancy centers. They're protecting abortion centers. And you can give me this in writing. I would like to get your read on what they are doing that protects the pregnancy centers and the health care that you're providing for expectant moms. Thank you, Mr. Chairman.
Senator Welch.
Thank you very much. Thank the witnesses. Mr. Chairman, this hearing is extremely important, but I also think it's in the context of a conclusion that I'm coming to, and that is that we have a crisis on the Supreme Court. The United States Supreme Court has a duty, is to strengthen our democracy and strengthen respect for the rule of law. Yet the United States Supreme Court, in many recent decisions, has, in my view, become a threat to democracy, and it has profoundly eroded respect for the rule of law. It's not just polls of American people that show a record low respect for the court, confidence in the court. It's not a popularity contest, of course. But the court has been making decisions with outcomes that are very contrary to the public interest. That's a point of view, but I think one that can be backed up with evidence. But it's also been using intellectual manipulation in reaching its decisions. And I think the public gets that. It's not on the level. Let me give 3 examples. We have a corrupt campaign finance system. Again, in the Supreme Court and Citizens United made an assertion of facts that I'll talk about in a minute to justify unleashing unlimited money, unaccountable money, undisclosed money to pollute our political process. In the Bruin decision, the United States Supreme Court came up with a framework of analysis, so-called historical analysis, which essentially made up a history of the way back to disregard the reality of today. And in the Dobbs decision, the Supreme Court disregarded precedent and stare decisis in order to achieve an outcome that we're now living with. The Supreme Court itself has added flames to the fire when some of those justices were before this committee in this room, Mr. Chairman. On this question of precedent, one justice told the committee in 2020, I will obey all the rules of stare decisis, and agreed that Roe was super precedent. In 2018, another justice told the committee that Roe is an important precedent in the Supreme Court, which has been reaffirmed many times. And in 2017, still another justice told this committee of Roe, quote, a good judge will consider precedent of the U.S. Supreme Court as worthy of treatment like any other. And of course, we've also had recently the report of ProPublica about the ethical issues in the Supreme Court. So I have 2 concerns. I don't know if I'll have time, but one is for Professor Goodwin about what I would regard as the departure from the doctrine of judicial restraint to a doctrine of judicial flexibility to achieve outcomes of the court. And the second is for Ms. Zyroski, who thank you for being here. You've spoken about your own experience, but there's moms who've lost kids because we are not allowed to pass gun safety legislation that meets the Supreme Court muster. There's citizens who are in agony about their democracy being ruled by folks who can give multi-million-dollar contributions. And there's women like you who are suffering because they've lost access to the health care that they need. So I'll start with you, Professor Goodwin.
Thank you very much, Senator Welch, for your question. As you mentioned, the outcome determinative of the Dobbs decision, and you're absolutely right. One day before, in the Bruin decision written by Justice Thomas said that a prologue was necessary to understand the history of men and their bodily autonomy, specifically black men. He spent 5 paragraphs in the Bruin decision describing black men historically, discrimination against them during slavery and Jim Crow, and how their bodily autonomy mattered, and how gun safety, or having guns, was important to that. You will not find a prologue mentioning anything about women in the Dobbs decision. 2 words that you will not find in the Dobbs decision, black woman or black women. Together, you will not find 5 paragraphs that speak to the forced and voluntary nature of reproduction of black women during slavery, being forced into pregnancies. You will not read anything about black maternal mortality in the Dobbs decision. So one day before, 5 paragraphs devoted to it. In the Dobbs decision, absolutely nothing. And as we look at this kind of turn to history, as you've mentioned, it's selective, it's opportunistic, it cherry picks through history. Let me just say this, Roe v. Wade was a 7-2 decision. 5 of those 7 justices were Republican appointed. Prescott Bush, the father of George H.W. Bush, was the treasurer of Planned Parenthood. In the Roe v. Wade decision, what Justice Blackmun mentioned, and is absolutely right, abortion had not been criminalized in the United States. The Pilgrims had performed abortion, so had indigenous people. When abortion becomes criminalized in this country, it was leading to and around the time of the Civil War. And we see some of the same rhetoric today used then, the concern about the browning of the United States. And that was the impetus for early abortion laws during the time of the Civil War. And we see the same kind of rhetoric today.
Thank you. My time is up, but I don't know if we can allow Ms. Zyroski just to speak on briefly on behalf of essentially the federal damage of these decisions.
Thank you. And thank you for the opportunity. I'd like to address this repeated attempt by the Republicans at a vulgar mischaracterization of what someone who needs an abortion looks like. Frankly, it's stigmatizing, it's offensive, and it's unrealistic, and it doesn't reflect who needs an abortion or who wants an abortion in this country. And quite frankly, healthcare should not be a meritocracy. You shouldn't have to deserve healthcare in order to access it in this country. And what's going on is not an accident. As I mentioned before, when Dobbs first came down, the Biden administration put out guidance on who should and could receive an abortion. And in Texas, in my home state, Attorney General Ken Paxton sued over that guidance. And so that guidance was revoked. And so again, as I said before, what happened to me was intentional.
Thank you, Mr. Chairman.
Thanks, Senator Welch, and thank you to our witnesses. There are a few points I'd like to make for the record as we close. One is on clinic violence. I want to make it clear, I think we have made it clear, it bears repeating, there is no excuse, underline no, for violence on either side of this issue, none. And to harass physicians or those who have an opposite point of view is unacceptable from my point of view, and I hope the Department of Justice will treat offenders on both sides of that issue the same way, with force, to stop, protect those who have a point of view on this issue. Second thing I want to say is the argument that this is about states' rights. What happened in Amarillo? Was that about states' rights? Here was an effort to eliminate the use of a drug which is used for chemical abortions nationwide, and that's what this Amarillo judge set out to do. So this is about more than states' rights. I think it's about a point of view that goes much further. And finally, let me say, I'm going to add into the record, I think it may have been here already, but a statement by the American College of Obstetricians and Gynecologists that is part of this hearing today. They went through specific examples of some of the most outrageous cases you can imagine already under Dobbs. One I'll read to you. An OBGYN who was contacted by a social worker about an 11-year-old sex trafficking victim who was pregnant. Not only was the physician unable to perform an abortion under state law, 11 years old, unable to perform an abortion under state law, but the social workers were unable to help the child obtain it in another state without risking prosecution themselves. The 10-year-old in Ohio, we've already made reference to. Come on. We're better than that as a nation than to let this disintegrate into this reality. The reality is that the shameful situation needs to be resolved, and I don't know if it can be politically, but I hope this hearing moves us closer to that day. The relentless assault on reproductive rights has to come to an end soon. I'm going to pledge to continue my efforts in this committee to make sure that the light is being shown on these issues and work with my colleagues to enshrine protections for reproductive freedom. The committee stands adjourned.